for cancellation and appointment of Gawra. I am the respondent, my lord. All
Monday.
Published.
May please your lordship. Lord, may I beg your lordship to mention item number 15 of the daily copy. May it be taken after 2 weeks, better.
Item 15
Item
and
15.
the request of Mr. B.C. Das, Learned Senior Counsel, appearing for the petitioner. Matter stands adjourned for 2 weeks.
May please, Lord. I beg to mention item number 16, Lordship. Matter may be adjourned
16.
1/6. 1/6. Matter may be adjourned 40 days. Today we are not prepared, Lordship, for arbitration.
Item 16 passed over at the request of Mr.
ABT hope.
ABT Hope.
May it please, my lord. My lord, item number 10, my lord, it has become infructuous, my lord. My lord, it may be allowed to withdraw, my lord.
Mr. A.
Only, my lord,
Chaudhary,
liberty may be granted, my lord.
Mr. A. Chaudhary, Learned Counsel for the petitioner, submits on instructions that the writ petition has become infructuous. And therefore, the petitioner does not wish to press the writ petition any further. Accordingly, the writ petition stands dismissed as infructuous. Interim order, if any, stands vacated. Anyone for the respondent?
FCI, my lord, Food Corporation.
Standing Counsel FCI appears for the
Obliged, my lord.
respondents. Writ petition is therefore closed with liberty.
Obliged.
My lordship, item number 7, kindly adjourn the matter. Learned English Council, Mr. T.N. Srinivasan sir, out of station for better treatment matters.
Item 7 at the request of Mr.
N. Islam, I am appearing on behalf of
N.S.
N. Islam.
N. Islam, who submits on behalf of Mr. Srinivasan that he is unwell. The matter stands adjourned for a week. For 1 week.
4 weeks, my lordship.
4 weeks.
Serious health condition is very serious.
Let it come after 2 weeks. 2 weeks.
My please, Lordship. I beg to mention item number 40 and 41, Lordship. Matter will be adjourned for 2 weeks, Lordship.
Why?
Senior is not feeling well, Lordship. She is having stone in her kidney, Lordship. And
In 17, 18 matters. We are
For-
passing it over for a week. Let us see.
for 2 weeks, Lordship, because next week she will go for medical treatment, Lordship.
It is submitted by
And Das, Lordship.
NDAS
On behalf of A. Bujarburwa.
on that MSA Buzar Burwa Learned Counsel appearing for the petitioner is in under medical treatment. Therefore, the matters there's a request for an adjournment for 2 weeks. Any interim orders?
No, Lordship.
Prayer is not objected to by the Standing Council Health and BTC. Matter stands adjourned for 2 weeks.
Lordship, I beg to mention item number 35.
35.
In this matter, the order has been complied with. Lordship.
Item 35 is submitted by the Learned Counsel of the petitioner, Mr. D. Chaudhary.
Mr. Dina appears for the respondents, my lord.
Yes, that the directions contained in the order dated so and so passed in WPC so and so stands complied with and therefore the petitioner does not wish to press the contempt petition any further. Mr.
D. Nath, my lord.
Your name.
I am D. Kolita, man.
D. Kolita appears on behalf of Mr. T. Nath for the respondent, who does not dispute the submission made by the petitioner. Accordingly, contempt petition stands closed. Notices are recalled. Yes.
Obliged.
Do you have a copy of that order?
I do not have the, I can provide it, Lordship.
You get a
That's
copy. Yes. Copy of the order
May I be the lord?
is kept in the case. Yes.
Lordship, I'm taking for listing repetition of 2016 letter, lordship. And obliged.
I beg to mention item number 11. In this matter, I want to file rejoin the repetitive matter. So 1 week time may be granted. Item 11.
Item 11 at the request of Mr. M.K. Sharma, matter stands adjourned for a week, enabling him to file rejoin the affidavit.
Obliged.
Matter adjourned.
So also, I like to mention item number 9. 2 weeks time may be allotted for filing IA.
Item 9.
9.
You are making on whose behalf?
Your Lordship, on behalf of Novosity Board,
Item number 9.
9.
Petitioner, respondent,
Petitioner.
some other name appears in the cause list, item 9. Look into the cause list.
Lordship, 2 weeks time may be allotted.
Is this the item or some other item you are mentioning?
Item number 9.
Item number 9 is shown to be fixed matter. You wait for the matter to be called up.
May it be the
Yes,
Lordship. May it be the Lordship. Lordship, I beg to mention item number 17, my lord, may come up after 2 weeks.
why?
My lord, conducting council is out of session, my lord. So, on
Hmm.
behalf of conducting council, my lord, I'm praying that adjournment slip was given yesterday.
Any interim order?
No interim order.
Right, item 17 at the request of Mr.
RH dear.
R. A. Chaudhary, matter stands adjourned for 2 weeks as the adjournment slip has been circulated and consent obtained.
Deep there.
May I please your lordship? In this matter, lordship, the petitioner, he was working as assistant agricultural inspector, lordship, and he retired on superannuation on 31/3/2018. So during his service, lordship, there on 1/6/2017 at page 10, lordship, there was an approval from the Joint Secretary to the Government of Assam for filling up 110 posts of agricultural inspector from assistant agricultural inspector. But lordship, that promotion he was not considered, and ultimately he retired on superannuation on 31/3/2018. He was within the zone of consideration because his serial number is 58 in the gradation list and the post to be filled up was 110. Now,
What does the
lordship, he
rule
has-
say? What does the rule say? Rules?
Rule lordship will find at page 13.
Yes. Relevant rules?
Relevant portion, page 14.
Mhm. He was working as,
Assistant agricultural inspector,
so from there he wants to be promoted to.
agricultural inspector,
All right.
11(1)(b). 11. All vacancies in class 1 and class 2 cadre shall be filled up by promotion in the manner provided hereinafter. B is relevant from assistant agricultural inspector and equivalent post in class 2 to agricultural inspector and equivalent post in class 1.
Yes.
Now, lordship will see the approval, page 10.
Page
10.
10.
With ref-
Yeah.
With reference to your letter on the subject cited above, I am directed to say that government has accorded approval for filling up of 110 vacant post of SAS1 AI. AI means agriculture inspector and its equivalent post cadre, which are proposed to be filled up by way of promotion from the cadre of SAS2, that is AAI and its equivalent post. Now, in the gradation list, lordship will see gradation list page 15. Page 15. His serial number is 58.
Hmm.
Lordship may kindly come to page 15.
Yes, yes. You are 58.
I am 58. Supposed to be filled up was 110. So he should have been considered, but without any consideration, he ultimately retired on superannuation, lordship. So retired on 31/3/2018. So now, lordship,
Has any post been filled up in the 110 sanction?
actually, lordship, after notice was issued, they have not filed any reply. And he is out of service, so he has no proper instruction, lordship.
Lordship, actually, we have earlier government has appeared in this matter, Lordship. For the first time, we have appeared, Lordship. 2 weeks may be granted, Lordship. I have to reconstruct the file and instruction will be called for, Lordship.
I have a small prayer, lordship. Matter has been pending since 2018. man has also retired in 2018, Lordship, and we are also not in touch with him. So my
You
humble
consider,
representation is also pending at page 22, Lordship. If that is considered and disposed of, Lordship. we'll see.
yes,
Lordship,
you consider his
Lo-
prayer.
representation may be considered. Lordship.
He heard. Learned counsel for the petitioner. This writ petition has been filed by the petitioner, claiming promotion to the next higher grade of agricultural inspector and its equivalent post. The petitioner was working as assistant agricultural inspector. Stop. By communication dated 1st of June 2017, the Joint Secretary to the Government of some Agriculture Department conveyed the approval of filling up 110 vacant posts of SAS hyphen 1 within bracket AI, which is agricultural inspector and its equivalent post. Stop. These posts were to be filled up by promotion from the cadre of SAS 2, which is assistant agricultural inspector and its equivalent post. Learned counsel for the petitioner, referring to the service rules, namely the Assam Subordinate Agricultural Service Rules 1994, submits that as per Rule 11, the all vacancies in Class 1 and Class 2 cadre are to be filled up by promotion in the manner provided. Under Rule 11B, 11(1)B, from the agricultural, it is provided that from assistant agricultural inspector and equivalent post, promotions shall be made to agricultural inspector and equivalent post in Class 1. Stop. Assistant agricultural inspector is Class 2 post and agricultural inspector is Class 1 post. Stop. Learned counsel for the petitioner has also referred to the final gradation list of the SAS hyphen Roman 2 cadre officials of subordinate agricultural service as on 31st January 2018, including Karbi Anglong Autonomous Council and Dima Hasao. The position of the seniority position of the petitioner was at 58. Stop. Counsel for the petitioner submits that in view of the sanction received by the department for filling up 110 posts in Class 1 cadre, and in view of the position of the petitioner in the seniority list, he was well within the zone of consideration, and therefore his case ought to have been considered. However, the same was not considered by the department, and the petitioner came to be superannuated on. When did he retire?
Lordship,
When did he retire?
31/3/2018.
31/3/2018. Under such circumstances, the petitioner being aggrieved has preferred a representation dated 9/3/2018, ventilating his grievances before the competent authority, who is the director, agriculture department. Stop. However, the said representation came to be said representation was also not disposed of. Stop. Finding no alternative, British petitioner has approached this court filing the present petition. MS
Z. Bora, Lordship.
G. Bora Learned Counsel appears on behalf of the Agricultural Department, had prayed for some time to complete her instructions and file affidavit if so advised, as it is submitted that she has been recently engaged by the department. You're recently engaged.
Lordship,
You're recently engaged by the department.
Lordship.
Stop. Here. At this stage, learned counsel for the petitioner submits that the writ petition can be disposed of, may be disposed of with the direction to the Director Agriculture to consider his prayers ventilated through the representation dated 9/3/2018, which had remained pending, and pass appropriate orders thereon. Stop. It is submitted that since the petitioner has retired and superannuated in the meantime, if the department had proceeded with the promotion at the relevant point in time and the petitioner's case could not be considered, then the benefits accrued to him should be released. Stop. MS so-and-so appearing for the respondent does not oppose the submission made by the learned counsel for the petitioner. Where having heard learned counsels for the petitioner and upon due perusal of the writ petition, this court is of the view that since the department has not filed their affidavit and the learned counsel has also prayed for some time to complete her instructions, ends of justice will suffice. Ends of justice will be served if the writ petition is disposed of with a direction to the Director Agriculture to dispose of the representation dated 9/3/2018 stated to have been filed by the petitioner and on which no order has been passed. Stop. The director, while disposing of the representation, will take into account the grievances of the petitioner for non-consideration of his case for promotion to the next higher grade of agricultural inspector in terms of the service rules and in view of the sanction granted by the secretary, joint secretary, communicated in view of the sanction granted by the government and communicated by the joint secretary to the government of Assam Agriculture Department by the communication dated 1st of June 2017. Stop. If the grievances raised by the petitioner are found to be correct, then appropriate orders thereon should be passed by the director. Stop. If the members of the service of agricultural assistant agricultural inspector from grade 2 are promoted to grade 1 and the petitioner's case has been overlooked, then the department will consider his claims and confer the benefits accrued to him as available under law. Stop. A copy of the order passed by the director as directed, as directed above, shall be served upon the petitioner. Stop. With the above observation, writ petition stands closed.
Lordship, may give a time frame.
The director will dispose of the representation within a period of 60 days from the date of receipt of certified copy of this order.
So along with writ petition, Lordship.
Why? It's available there. You have a copy. If you want, you can serve it. Dispose.
Excuse me.
May I please, my lord? My lord, the petitioner before my lord. While working as my lord a CDPO, he got enrolled in a first that NIA case, and then he was convicted. In pursuance of his conviction, if my lord can come straight to that order at page 48. Sorry. Page 29.
Yes.
Whereas so-and-so, the then CDPO Deputy Director so-and-so was arrested on so-and-so in connection with so-and-so on the ground that had entered into criminal conspiracy with other person. Then, my lord, the facts have been narrated. Then, my lord, second paragraph. Whereas so-and-so was subsequently convicted in NIA case number so-and-so by Honorable NIA Special Court Guwahati, Special NIA so-and-so found him guilty under section 120.
This has been set aside.
And this was the sole ground for which he was, my lord, dismissed.
All of them.
All of them. The judgment.
Lack of evidence.
Lack of evidence, improper investigation, no connection. The charge under the unlawful prevention of unlawful activities. There was no charge, nothing framed. Basing on a conclusion drawn with the other 120B, that was also said to be true.
All right.
So, this has to go, and I'll have to be reinstated back, subject to, my lord, what further action they take in course of their raid. The last paragraph, my lord, will reveal that this is only because of this that I was.
Now, who's for these respondents?
The government.
Yes, government.
Right. My lord, this order was under stay, and I was directed to be under suspension, my lord. It's another thing, they have not even released any subsistence allowance to me till date.
Maybe you don't need the substitution
Now,
clause.
if need is there.
Now,
Now need is there.
yes, madam,
Lordship,
you have to go through this.
yes, I need to go through, but data part,
Everything has been set aside, and if your dismissal is solely on that ground,
Only on-
yes, Lordship.
then you'll have to reconsider.
My lord can interfere with that, remand back the matter. My lord, they will take a call.
Let them go through this, find out.
Lordship, in
Because
this
my
matter,
lord,
Lordship,
here-
then the department, Lordship may remand it back, Lordship.
Then we'll have
Not
to set
remand
aside.
We'll have to set
We
aside.
can't remand like that. We'll have to set aside this order.
Order.
And we'll have to record your submissions that you want the matter to be remanded back.
The remand can only be with regard to, my lord, the payment of salary. That's all.
Lordship, I shall also take instruction. Lordship may post it on Monday even, Lordship.
We'll give you some more time.
Yes, Lordship. Monday, Tuesday, it can be.
What was the ground on which it was imposing a dismissal?
Dismissal, my dismissal, my lord.
Yes.
Page 29, last paragraph. Whereas the file was endorsed to the judicial department and legal remembrance and so and so, why they dated that the officer can be removed, dismissed from service under the proviso to article so and so of the constitution read with rule 10 of the Assam Services Disciplinary Appeal Rules. Then, my lord, the next paragraph.
It was divorce any inquiry.
No inquiry. No inquiry.
311 2C. Perhaps, madam, you'll have to.
But under 311 to Lordship, it can be without inquiry, Lordship.
No doubt, no dispute
Yes,
on that.
Lordship.
But if it is entirely for this reason,
Lordship.
then this having been
Lordship.
interfered today, then you'll have to think about it.
My lord,
And your files will reflect the reasons of not out dispensing
Yes,
with an
Lordship.
inquiry.
I'll have to be brought back from, my lord, 11/8/23. That was the date when the conviction went.
Or you get your instructions on
Lordship.
this.
Lordship.
Because 311 2C is for us generally
conviction.
Yes,
certain
Lordship.
conditions are there.
Yes, Lordship.
My lord, what have they have done? The conviction was made by the trial court, immediately taking recourse to 311 proviso that they have, because my conduct led to that criminal conduct, they terminated, they dismissed him. Now that conviction gone, here, my lord, there is nothing left. Another thing, my lord, the question whether, my lord, it is an honorable acquittal, not whether it's an acquittal with some that will also not arise here because it's after conviction.
It has been set aside. So technically, the order of conviction
Technical,
goes. There's nothing there.
Nothing.
You're not convicted.
It's not that. From the day beginning, my lord, I'm free now.
Heard learned counsel, Mr. Senior counsel, Mr. U.K. Nair, assisted by Mr. R. Islam. And MS M. Bhattacharjee, learned additional senior government advocate appearing for.
My lord, my friend would appear for 1, 2, 3 social welfare.
Okay.
Social welfare.
I'm for 1, 2, 3, and 6, Lordship.
1, 2, 3, and 6. Mr. Konikor for respondent number 5. This writ petition is filed challenging the dismissal of the petitioner. Dismissal from service of the petitioner by order dated 17th May 2008.
Lordship, I shall appear for 4 also.
Respondent
Hilarious.
4. Order dated 17th May 2018, whereby the petitioner was dismissed from service with immediate effect under the provisions of Article 311. Stop. The dismissal, the learned senior counsel for the petitioner submits that the dismissal was solely on the ground that he was convicted by the special NIA court, Assam, by the judgment and order dated.
I'm just giving that.
So and so, passed in NIA case number so and so. Stop. Learned senior counsel submits that in an appeal filed, in a bunch of appeals filed by the convicts, filed by the persons convicted, including the present petitioner, a division bench of this court has interfered with the findings of the trial court and has set aside the conviction. Is set aside and quashed. And the appellants are all acquitted of the charges. Is there any reference to the petitioner? What?
My lord, yes. My lord, it would be para 234, my lord. Here, my lord, only Joel, Niranjan and Mohit were in custody. So, my lord, they were allowed to go, but we were on bail. So, my lord, that was done.
The petitioner was already on bail.
Lodge.
In the meantime, stop. The learned government advocates submit that they require some time to obtain the instruction in the matter. And file affidavits if so required in the matter. Let the matter be listed again on 11th?
Lordship.
11 September.
My lord, one factor. On 10/8/2018, this honorable court had stayed this dismissal order, but directed that I shall remain under suspension. No subsistence allowance. That, my lord, will take care of together. And the NIA case number is, my lord, NIA special NIA case number 1 of 2009. And the judgment is 22/5/2017.
There are two cases, I think, 1 and 2.
1 and 2 were heard together, my lord.
What is your case?
Mine is 1.
One special NI case.
One.
of 1 of 2009. And against which appeals were filed
Yes, sir.
and heard before this court, and the matter was heard. Stop. Similar appeals were also filed in respect of NI case number 2 of 2009. Both these appeals were heard together
Both were, my lord, heard in
by this court in criminal appeal number 238 of 2017 and the other bunch of cases, connected bunch of appeals. The appeal preferred by the petitioner is criminal appeal 233 of 2017. And judgment and order of this court is 11th August 2023.
much of.
Deeply honored.
List on 11.
Please, your lordship. Regarding regulation service of the petitioners, my lord. The petitioner initially serving as my lord, circle organizer, village district organization, my lord, from the year 1993 and 1996, my lord. And in pursuance of that, my lord, court order, my lord, kindly see, my lord.
Lordship, in item number 4, Lordship, though the matters are analogous because the matters are almost similar. In item 4, Lordship, we have just received the instruction. We need to file affidavit, Lordship.
Okay.
In the other case, it is already filed, but here it is required.
You are appointed as casual employee.
Casual employee to act as
Temporary.
SEO video. The year 1993, my lord. And
So what is your prayer now? Regularization.
regulation, my lord. And my lord,
But regularization will have to follow if there is a rule, it will go by the rules.
my lord, kindly see, my lord,
The only claim you can have is Upendas.
my lord. But subsequently, in pursuance of the court, honorable court order of this honorable court, my lord, the 2 appointment order issued, my lord. Kindly see page 68, my lord.
68.
68,
In item 3,
item 3. Initially, my lord,
Honorary.
they were terminated, my lord.
Then you are appointed as honorary. They are appointed as honorary, temporary
Honorary.
basis.
And subsequently, another appointment order was also issued, my lord, kindly see page 74, is a home guard, my lord.
For a period of 6 months.
6 months, my lord.
These are all
Yeah.
temporary appointments.
My lord, I am, my lord, serving since 1993, my lord.
Maybe, but that
And,
cannot be a ground for regularizing you unless there is a scheme by the government.
my lord, 2
It can be your claim that you are not allowed to participate in regular selection process.
2 sanction posts already there, my lord. In subsequent,
So-
my lord, earlier advertisement.
Then
my
we
lord.
direct them to proceed with the regular appointments,
My lord,
and your services will be given benefit of, including aid.
my lord. Subsequent case, my lord.
Hmm.
State 2 sanction post, my lord, without any advertisement, my lord. My lord, centrally, my lord, appointed 2 persons, my lord.
Which pace?
My lord, item number 4, my lord.
Item 4. Yes.
Item 4, my lord. Order, my lord, 97, my lord.
97.
97, my lord. And 2, my lord, CO video, my lord, already appointed, my lord.
97.
97, my lord,
Hmm.
item 4, my lord. It is the order of, my lord, appointment, my lord.
They're appointed as what?
Yes, CO video, my lord. Circle organizer, village defense organization. Name of the post and 2 posts, my lord, under Nalbari district, my lord, Pine district, serial number 70 and serial number 100.
Yes.
Centrally, my lord, the state level selection committee, my lord, the state order was passed to appoint a 2 person, my lord. And now, my lord, I have informed from the received the instruction from the client that, my lord, their 2 person has not joined till date, my lord,
Yes, this is.
These 2 persons have not joined.
non joined, my lord. So, my lord, the state 2 second post already,
No, but these appointments were made as a part of what? As per recommendation of state level selection commission.
my lord, without any other such recent GST appointment, my lord. Without any advertisement, my lord.
Yes, madam.
Lordship.
He
This is how
says-
it can be no without
I
advertisement.
don't know, it is for
Lordship.
you
Yes,
to tell us.
Lordship.
It is
Because
for you
these
to
were the
tell us.
common, Lordship, the common test conducted, Lordship, for grade 3 and 4.
Hmm. You cannot have
In the
that
earlier
direct
occasion, my lord.
recruitment, rehearse the rules without any
Lordship.
advertisement. This is as per recommendation of state level selection commission.
State level selection commission.
Under what rules?
Lordship, we shall come back with the affidavit, Lordship. We have received instruction.
You are challenging their appointments.
Appointment, my lord.
Serial number?
Serial number 70 and 100, my lord.
Serial 70.
70. Kishore Kumar Boisho. Name of the post circle order PTO and name of the office to which candidate is posted SP Nalbari. And
70 and
100, my lord. Serial number
100.
100 is 104. Earlier round of litigation, my lord, the same 2 post was advertised, my lord, and this honorable court, my lord, said the advertisement, my lord.
Third learned counsel for the parties. Now, what is the okay, notice also served on respondent 8, 7 and 8. Anyone for 7 and 8? Third learned counsel for parties. This writ petition is filed by the petitioner putting to challenge the appointment of respondents 7 and 8 in the post of CO video by order dated 24 May 2023. Stop. The petitioner claims to be working. Where is your appointment order?
Order, my lord, my lord. In item number 3, my lord,
Yes. Page 25.
25.
He is working as
In his,
a casual employee.
my lord, 19 and 20, my lord, initial appointment. Page
Hmm.
number 19.
19.
19
of the writ petition.
of the repetition.
In item 3.
Item 3.
Okay. In 4, it is 25.
Now 19, you are referring to which paragraph?
My lord.
Oh, sorry, this is item number,
3, my lord.
okay, okay.
Instead of 96, but they are stating it to be 93.
Was appointed as casual worker, casual employee under contingency expenditure and is allowed to work as CO video at Belsor Police Station by order number 1562 dated 31/5/1993, issued by the Superintendent of Police, Nalbari. Since then, petitioner has been working
Item number 3, my lord.
As a-
Petition of my lord.
as a casual employee as CO video. Stop. Petitioner is aggrieved by the selection and appointment of there are no private respondents here.
Item number 3, not there, my lord. Yes,
There
2019
are
and all the
item 3, there are
vaccine
two petitioners. One was appointed on 31/5/93, the other on
96.
22/3/96. Both in PS Belsor, Belsor PS. Stop. Petitioner is aggrieved by the fact that in spite of long service rendered, they are not selected and appointed as CO video on regular basis. While such steps have been taken by the department in respect of other similarly situated persons. Stop. Under such circumstances, the petitioners have approached this court praying for appropriate direction for consideration of their cases for regularization / regular appointment as CO video. Stop. The respondent number 5, the SP, Nalbari, has filed the affidavit. However, Department of Home has not filed their affidavit as on date. MS Bhattacharya, learned counsel appearing for the learned government advocate, appearing for all the respondents. Praise for and is granted 2 weeks further time to complete her instructions and file necessary affidavit. Matter will be listed after 2 weeks on a date to be fixed by the registry. Insofar as item 4 is concerned, there the writ petitioners, how many writ petitioners?
1, my lord.
1. He was appointed as casual employee under the Tihu police station as CO video. And since then he's been working, rendering his services. He is aggrieved by the selection and appointment of respondents 7 and 8, who were recently appointed by order dated 24th of May 2023 as CO video in
Under Nalbari district.
under the Nalbari district. Stop. Learned counsel for the petitioner submits that this selection was made without any advertisement, and a bare perusal of the order, which is enclosed as Annexure 23 of the writ petition, reveals that these appointments were made on the recommendation of State Level Selection Commission for Class 3 posts. Stop. Learned counsel for the petitioner submits that the manner in which the appointments are made are contrary to the provisions of law, and no advertisement having been issued, the petitioner was not aware that the selection process was being conducted, and therefore he could not participate in the said selection process. MS Bhattacharya, learned counsel appearing for the respondents, pray for 2 weeks' time to complete their instructions and file necessary affidavit. Stop. Office note reveals that services on respondents 7 and 8 are completed by registered post 80. However, none has represented them when the matter is called up. List again after 2 weeks.
Obliged.
Deeply obliged. Your Lordship.
May I please, Your Lordship? My lord, here in this case, my lord, one disputed fact has arisen, my lord. Petitioner before your lordship filed this writ petition praying for my lord family pension due to the death of her husband on my lord 21/1/2003, my lord. In this regard, my lord, I have annexed my lord death certificate, my lord. Page 10, my lord. And my lord, it was followed by the next of kin certificate issued by my lord, the concerned authority. This is DC office, my lord, Hailakandi district, page, my lord, 11 annexed 2. And it was followed by my lord, 2 other Bhutan list, my lord, latest also. One, my lord, 1997, here also donor.
When did you file your application?
My lord, it was last filed, my lord, application.
What do you mean last file?
Yes, my
There
lord,
has to be one application.
2019, my lord,
Page number
page number 20, my lord,
20.
20, my lord. But my lord, here another fact is that, my lord, now my lord, government side has filed one affidavit that, my lord. Then my lord, the son also claimed, my lord, who was my lord, then minor, claiming family pension, my lord, and he stated in his application that, my lord, this petitioner stated to him, my lord, that once, my lord, that he is remarried, my lord. So, my lord, under such circumstances, my lord, this matter has been, my lord, disputed materially. Therefore, my lord, I beg to, my lord, submit before your lordship. At this stage, my lord, considering, my lord, my latest application, my lord, page 20, my lord, and this son's, my lord, purported application, it is, my lord, they annexed in the, my lord, annexure 3, in the, my lord, page, turning page 35, my lord. So, my lord, at this stage, my lord, it may be better, my lord, if respondent authority, my lord, hearing both the parties, my lord, and she has another son also, my lord, in the next of kin certificate, my lord. They both are also respondent here, my lord.
What do they say in their affidavit?
My lord, in their affidavit, my lord, page 35, my lord. Here one line is there, my lord. This son, my lord, submitted this application, my lord, in the year 2019. And she stated that, my lord, he was minor, my lord, then when father died, my lord, and he was, my lord, grown up by his father-in-law, grandfather, my lord. And mother once came to him, my lord, and stated to him that, my lord, she is remarried, my lord. Page 35, my lord, it is my lord, purported application, my lord. Under such circumstances, my lord, my application, his application, taking together, my lord, department, if at this stage, my lord, pass any speaking order, hearing both the parties, my lord, and he has.
Yes, who's for the department?
I'm accused for that because
Why you have not released the pension?
Lordship, at the time of his death, your lordship, he has not filed any detail of his family. He died on harness, your lordship. And thereafter, his father has made one affidavit where he stated that his wife is not missing for last 5 years.
Yeah, you can't rely on an affidavit. There has to be an FIR or something.
Yes, your lord, that
Then-
is true, your lordship,
then-
but But because that time there was no claimant, your lordship, at the date of the
What is the position now?
lordship, it is unsettled, your lordship. There are two claimants, your lordship.
How can there be two claimants? How can the father-in-law claim in the
No,
face of the
not father-in-law,
sons?
son and wife.
So if wife is there, then it has to go to the wife.
But there is one fact that she is remarried, your lordship. That is not clear, your lordship. The wife of the petitioner also not given such clarification, your lordship. If she is remarried, how could she claim, your lordship? And that is, and then too after.
On what basis have you got this information? She's remarried.
Lordship,
Page 35.
if 35, his son has said so, your lordship. My mother once visited my house after the death of my grandfather, but did not stay nor look me with her as she was remarried.
And it is, my lord, on the basis of statement of the petitioner, my lord, information of the petitioner, according to him, my lord. It is stated that, my lord, this petitioner before your lordship said to her, my lord, him, my lord.
Where?
My lord, paragraph, page 35, paragraph, my lord.
So you come to the application, page 35.
Yes, my lord. It is
Yes.
lastly, my lord, and was staying with his newly family as she had stated, my lord. It is his not own knowledge. So, my lord, with all the respect, my lord, I beg to submit, my lord. At this stage, my lord, it would be appropriate, my lord, if hearing the petitioner and her two sons, my lord, department, my lord, practically verifying the, my lord, past and take any decision in this matter, my lord.
Yes.
Our finding is clear, lord.
What?
With regard to
Where is the finding? There is no finding.
lordship, annexure 2,
Annexure 2.
yes, page 33.
Yes.
To the letter written by the authority to the petitioner. Your claim for payment of family pension against the Tyne Harness case of so-and-so. Paragraph 1 in your letter dated received from this office, as well as in your last letter dated nil received by this office. You have stated that you have been.
How will she have? How will she have papers to justify that she has not disappeared?
No, lordship.
It is the person making that allegation who has to justify.
Lordship, there is first the father-in-law of the petitioner. He submitted an application.
That she disappeared.
She was
Missing.
not known for last 5 years.
Missing. Any FIR has been filed?
That lordship, because
Will you rely only on an affidavit by the father-in-law, or will you make inquiries as per
no, lordship,
provisions
to
of?
see, but there was no claim for last many years. Then
May
suddenly
not
she
be.
appeared.
May not be. She may
Then
not be aware.
asked her to submit some documents. She failed. Then her son appeared. Said that my mother has already been remarried. And as per section rule 54, if the widow or disease, if this is remarried or she died, they are not entitled to any. It is burden lies on the petitioner to.
This pursuant to this letter dated 33, letter at page 33. Did she appear before? Did she file any reply?
No, lordship. Yes, my lord. Page 20, my lord.
In,
I
res-
the read petition, page 20, my lord.
in response to the letter, communication dated 1/1/2019.
Yes, my lord. Page 20, my lord. In the read petition.
Then what has been done after that? What orders were passed?
As per my information, nothing done, my lord.
Then
Lordship, thereafter, annexure 30, annexure 3, page 35. The son of the petitioner.
no. You had issued a letter at page 33.
Yes, lordship.
Pursuant to that, the petitioner says she has replied at page 20 of the writ petition. Any orders passed after that?
That doesn't seem any order, I think.
Exactly. You will direct both parties, all parties to appear. You
Yes.
conduct whatever
Yes.
investigation and pass an order
Yes,
immediately.
that means
Heard learned counsels for the parties. This writ petition is filed by Srimati so and so, praying that for direction to release the family pension and other pensionary benefits to the petitioner on account of death of her husband who died in harness while working in the office of the Deputy Commissioner of Customs, Karimganj. The husband of the late husband of the petitioner was working as a sepoy. Stop. The petitioner claims that in spite of our application to the concerned department seeking release of family pension, the same has not been released. Instead, by by communication dated 1/1/2019, the petitioner was asked to reply to certain queries put by the department on the basis of applications filed by the father-in-law of the petitioner as well as the son of the petitioner. Stop. The father-in-law had alleged that the petitioner had been missing for about 5 years prior to the death of the petitioner's husband. Stop. And therefore, she was not entitled to any pension. Stop. Similar allegations are raised by the son of the petitioner, who further stated that the petitioner had remarried in the meantime and has been living separately in her new family. And therefore, she is not entitled to family pension. Stop. Denying all such allegations, the petitioner had filed a response to the letter, to the communication dated 1/1/2019. Stop. This reply is dated
3/4/2019. 3/4/2019.
Where is the date?
Page 20, my lord, left hand side.
Page 20.
Page 20, my lord, left hand side, my lord,
Who
3/4/2019.
knows? Who knows who has written this date?
Yep.
Which is stated to have been submitted on 3/4/2019. Replying to all the allegations made against her. Stop. In her reply, she denied that she had remarried. Rather, she stated that she was driven out of the matrimonial house by the family members after the death of her late husband. Stop. And she had been working in a factory in Mumbai in the meantime. Stop. Learned counsel for the petitioner submits that in spite of this response filed by the petitioner, no order has been passed, nor any pension has been released in favor of the petitioner. Stop. The authorities have neglected to consider the claim of the petitioner for release of pension on account of the death of her husband. Stop. Para. Mr. SCKL, learned counsel of the petitioner, submits that as the department had already issued a letter as far back as 1/1/2019 requesting the petitioner to respond to the allegations made. Stop. Comma. No response has been received. What about this letter? Have you received this letter?
Lordship, that is,
Is number 20.
in fact, there is no endorsement in the letter.
Mr. KL submits that there is no record of the reply being submitted before the authorities concerned. Stop. Where having heard learned counsel for the parties, it is seen that the issue of release of pension on account of the death of, what is the name of the husband?
Nikhil, my lord, Das, my lord.
Nikhil Chandra Das, late husband of the petitioner. Comma, the matter needs to be resolved expeditiously. Stop. Considering the submissions advanced and the pleadings available on record, comma, this court is of the considered opinion that the matter should be relegated to the department to conduct a proper hearing in respect of the allegations and counter allegations made, and thereafter take a decision to pass orders in respect of the claim for pension of the deceased Nikhil Chandra Das. Stop. The petitioner will appear before the competent authority and the respondent authorities. Petitioner will appear before the respondent authority, and as also the respondent authorities will issue notices to the father-in-law as well as the son or any other claimant who may have staked their claim for family pension of Nikhil Chandra Das, and thereupon conduct a proper hearing and pass necessary orders in the matter. Stop. Since the learned counsel, since the petitioner is represented by learned counsel, no notice, no further notice is necessary to be issued by the department. However, the department will issue notices on, are there parties here?
Yes, my lord. Sons, my lord, 5 and 6, my lord.
They are not represented?
No, lordship. No, my lord. They are not represented.
Steps not complete.
My lord, advocate's name is shown, my lord, but not appearing. Where is the party?
The
No.
sons of
What is I think?
the petitioner are also arrayed as parties. in the present
In
petition as
in
respondents
petition
number 5
probably,
and
no,
6.
I hear the Kora.
The respondents 5 and 6 are represented by counsel, as is evident from the office note stating that wakalatnama in respect of respondents 5 and 6 has been filed. Who is the counsel here?
My lord, one B. Shohoria.
Please inform him.
Yeah.
The respondent authorities will also issue notice to the father-in-law. We will make it that all stakeholders will not give the name. The petitioner, and the respondent number 5 and 6 will appear before the competent authority within 30 days from the date of receipt of a certified copy of this order. Thereafter, the department will conduct necessary hearing in the matter and pass further orders within a period of 60 days therefrom. Any such order that is passed, copies thereof will be served on all the parties who appeared before the department. Stop. If the department, upon conducting the hearing, passes an order for release of pension, the same should be done expeditiously without further delay. Writ petition stands closed in terms of the above.
Developer.
My lord, standing counsel, Mr. B. Gogo will appear for this matter. He is occupied in court number 1, my lord, and this will take some time. The matter may be taken up after some time, my lord.
Item number,
6, my lord.
this is for what?
Well, this is a selection process, my lord, that is
Driver.
driver, my lord. Selection process of driver, that is.
Let him come at 2 o'clock.
My lord, at two.
Yes,
Lordship. This is a case also for non-payment of the salary, Lordship, and
somebody said you will file a review petition.
Yes,
Yes,
Lordship, I just, Lordship,
Because-
kindly post it on next week, Lordship. I shall get the information whether review has been filed or not, Lordship.
MS M. Bhattacharjee, learned government advocate, submits that as per last order, it was submitted that a review petition was required to be filed against the order passed in WPC 2092, 2015. Stop. She prays for a day's time to obtain instructions as to whether review petition has been filed or not. Mr. J. Kolita, learned counsel for the petitioner, does not object to the prayer made. The matter stands adjourned. When can you get it?
Lordship, any day next week,
31st?
Lordship.
31st.
Deeply obliged.
Let it be 30, 30,
30, Lordship.
30.
There is an order, mother. So can you finish the last order? Actually, I won't be able to prepare IE, mother. Because. So I can, I need.
Amendment.
Amendment, my lord.
Why amendment?
Only, my lord. Respondent number,
Die in harness.
dining harness, my lord. Respondent number, state level committee, represented by the chief secretary, but it is shown as member secretary, my lord. That is the point. So I have to file one IE, my lord, for correction. Earlier, my lord, we can correct by our hand. my
You
lord, but-
file amended course title in the registry. You file an amended course title,
Hmm.
we will permit you to file it.
It's-
Yes?
No problem.
What is the, you are claiming for what?
For appointment of grade 3, my lord.
Grade 3.
Grade 3. Earlier, he approached before this honorable court, my lord, and he was
Who,
recommended by the deputy commissioner, my lord.
you are claiming die in harness in whose place? In your father's?
Yes, my lord.
Your father was working.
Father was working as the assistant manager, my lord.
You have been handed the brief in the morning.
Yes, no, my lord. Actually, what happened, my lord?
Yes. Then
Lordship, if you would like to take up, then I can argue, my lord.
it is for you. If you want to argue, you can argue. You're welcome.
But no correction is made out. That's why.
We'll direct you. We'll direct the corrections to be made. But let us see.
Yes, my lord, the
Is it
father-
necessary to keep it pending or we can close
Yes,
it?
my lord, because
is
it
what-
is a case of 2021. My lord, what happened in this case, my lord? His father was died on 26/5/2005, my lord. Then he immediately applied, my lord.
Your case has been considered by SLC.
SLC, my lord, but till that, we won't be able to appoint, my lord. They could not appoint me, my lord,
Why?
Lack of vacancy.
for
Lack of vacancy.
lack of vacancy. But in OM, my lord, if there is no vacancy, then they can.
Where is the
accommodate
SLC minutes? SLC minutes?
Mind.
SLC minus page 56 lordship.
Petitioner earlier also approached, my lord, before this honorable court. Six. एकदम back.
What was the earlier direction of the court?
My lord, lordship kindly peruse the page 50A.
58. Yes. 58.
Yes, in
Or
inviting the
57.
subject, I am directed to enclose here a copy of the minutes. State level meeting for selection candidate for appointment on professional account. No conference.
57. You're a-
57, yes, my lord.
57C lordship.
Now-
57,
Para C.
Where is the earlier order of the court?
earlier order of the court is lordships. Page 55.
55. Yes. You'll have to, you are normally required to consider in terms of clause 15.
Yes, my lord.
Clause 15. Your page 57 reflects could not be appointed
There was only one vacancy, lord.
due to lack of
Vacancy, yes, lack of
vacancies.
vacancy.
That OM came subsequently, lord, so that could not be considered.
This is on when? This is on 18 January.
This is 18 January 2020.
What OM?
So lordship, I think one more time we can.
My
department
order,
can place the
I
case.
obtained the order 9/11/2018.
The OM is of 15.
OM is applicable.
First of June 2015.
One six
And the order of the,
SLC happened in January 18, 2020.
uh,
Oh, then.
So now that only thing is that death happened. Death of the person happened in 2005.
deaths, they have happened at any time, but the OM
Oh, that
is
too
for the purposes of considering these claims.
I think lordship, one more time, the case can be placed before the SLC lordship, because the effort is still there, lordship. The force.
The OM, my lord, it is 15 is stated that if there is no vacancy in that department, then they can be accommodated to any other department whichever vacancy is available. Okay, okay.
No,
We did.
actually, lordship, there was another SLC which happened in 2015. I just got it out here.
But this is in pursuance to the orders of the court.
That's
Yes,
correct,
ma'am.
lordship, but
My lord, minutes of the 2013, my lord, lordship, page 37. It is stated that District Industry Commercial, Commerce Center, Nalbari, one proposal for the junior assistant post was submitted, namely Navajyoti Burman, Atul Chandra Burman, and DLC decided to forward the proposal to the government for placing the SLC as the vacancy position get post is one. Then it is sent.
Then what happened to SLC?
SLC stated that there is no vacancy, only one vacancy is there.
No, this 2013
13
is a DLC.
DLC, my lord.
Pursuant to 2013,
His name is recommended, my lord. Then your lordship kindly.
then you come to court.
14 also, my lord.
2015 also, in fact, it was 49, it was in October. So they should have considered it. They could have considered
Who?
their SLC.
They
And
did
could
not.
have considered the OM while taking into account the vacancies. That probably they haven't done.
Then lordship kindly peruse the 41, page 41. Regarding the submission vacancy position relating to appointment on competition ground, my lord. Gate 3 post is, one post is there,
Page number?
page 41. One post is there, my lord. One post is gate 3 and one post is gate 4.
But by the subsequent,
Then lordship, page 42. Under secretary wrote a letter to the deputy commissioner, my lord.
Lordship, why I was telling about the death is that there is a Lordship has I think your Lordship has passed an order wherein it has been stated on the date, the particular person's date, whatever the OM is applicable, that will be taken into account. So in that case, Lordship, 2015 may not come because at that point of time, 2009 OM was there. So that was the thing, Lordship, I was pointing out. But obviously, also after the court's order, in 2020 SLC, they should have considered the OM if that particular order is there. But now the law is that
now, what was the earlier OM?
earlier OM was like, I mean that 5% vacancy there. But
Lordship,
later,
they have
but-
filed.
But
In-
this clause number 15, subject to correction, I recollect, was also a clause in Achyut Ranjan.
Lordship,
Yes, my lord, yes.
In the judgment of the court,
Lordship,
pursuant to which these OMs have been issued,
Lordship.
this clause 15 was perhaps there that you will
Yes.
consider in respect of vacancies.
Yes, Lordship, but now the.
And that question is
now-
only he raised in this,
Now
in
what
this
has
court, my
happened is
lord,
that, what I'm saying is that.
regarding
that
OM, my
OM, the
lord.
applicability. of
And
the
lordships,
OM.
in earlier case, my lord, they have filed affidavit also. Lordship kindly peruse page 52.
No, wait,
With
let-
regards to
let-
this statement, may I read, my lord?
Yes, let us hear him. We'll hear you also. We've heard. you.
Yes, yes.
Yes.
So, I mean, like, that law is now, which has been settled by this honorable court, is that on the time of death,
Because 50 is the latest.
whichever is the.
No, you're right. So let us see that.
That was the judgment that.
Achyut Ranjan. Achyut Ranjan. Do you have the copy of the judgment, Achyut Ranjan Das?
Actually, I'm not agreeing with that.
Take it out.
Yes, instruction number 10 has been-
Madam, do you have a copy?
Instruction, he take over, he took it. My lord, they have filed affidavit in my case, earlier case, my lord,
Hmm,
page 52.
yes.
They stated that the proposal of the petitioner Navajyoti Burman, son of Atul Chandra Burman, was recommended to the state government for appointment on compassionate ground for the post of junior grade 3 against one vacant post in the district level committee meeting held on Iman 38/3/2013. On basis of that, this honorable court passed an order, my lord.
Pursuant to this,
Yes, my lord.
this is a recommendation by the DLC. Pursuant to the recommendation of DLC,
Yes, my lord.
what was the recommendation of the SLC and on which date?
Lordship, kindly peruse the second para 6
Ah.
in affidavit. In response to the government letter dated 13/3/12/2014, clarification was issued to the government white letter dated 13/2/2015, stating that the proposal of Navajyoti Burman may be approved against the vacant post of grade 3.
No, correct, but
Yes.
where is the
Then
SLC
this
order?
honorable court pass an order.
That's right. So where is the SLC order after that?
They will place, my lord, the SLC
56.
56.
This is the SLC order after DLC.
Yes. As per direction of the court 57, all this proposal was placed before the DLC meeting. However, their case could not be considered for appointing, except the Sri Kanop Kaushik Padri. He already got the appointment, my lord. And lack of vacancy, appointment. If there is a lack of vacancy in that department, my lord, then OM 15 comes, my lord. And this honorable court pass an order on basis of that OMs, my lord.
Mr. Kolita has raised a issue that the OM which was subsisting on the deaths, on the date of the death of the employee is the OM which is to be considered. So therefore, I want to know whether in Achyut Ranjan Das and
Yes,
other
yes,
subsequent
yes.
judgments,
Let the matter be listed at 2 PM, then I can.
yes, all right, at 2 PM.
Lordship, that judgment, Lordship,
Hmm.
that which has been passed.
You give us a copy, let us also have the benefit at 2 PM. We'll also try to get a
2009.
copy. Yes.
Highly obliged.
My lord, in this case, I pray for 6 weeks time, my lord.
Just 1 minute.
Lordship, take this some short date, Lordship, because
Very short, copy as
2021 matter, Lordship.
ये दो जजमेंट निकाल के करने दो। दो जजमेंट yes.
Lordship, 2021 matter, in this case of the petitioner has already retired from service. Day one of the financial benefit. And Lordship, the standing council or I think can take the instruction whether we are entitled for financial benefit or not. We have been.
You are praying for
6 weeks time.
6 weeks.
Because, my lord, both of us, we have lapsed, my lord. Not only on my part,
Case has
his
been
part.
for a long time. that is
No,
why-
let us,
That is, my lord.
6 weeks is a very long time. We'll
Till
give
that, my
you,
lord,
we'll
we
give
have
you
to-
3 weeks time to obtain your instructions. Let us-
because, my lord, till that, no communication with the authorities, my lord. That
Very
is
well,
the-
you can initiate the communication, but we can give you an adjournment for 6 weeks time.
That is why, at least after 6 weeks, in a that, my lord, matter can be disposed of.
Let us first see what comes in 3 weeks.
Then 4 weeks, my lord.
Yes. Learned counsels for the parties submit that matter be listed after 4 weeks, enabling the then Department of
My case is like that, Lordship. We have been.
Water Resources to obtain the
Oh,
required
bhai.
instructions
Kidnapping submit to Baji ke baad.
in respect of the claims of the petitioners who are claiming notional promotion to the post of additional chief engineer. Matter be posted after 4 weeks.
Obliged.
We have been recommended for promotion. There are the promotion has been granted.
You should argue all that day, my lord. Today, yes, sir.
4 weeks.
May please your lord. But respondents number 3 to 6, I think, have filed their affidavit today. I've received a copy a while back. Perhaps that is not on record either.
They filed today.
Yes, my lord, we are filing it.
Respondent number,
3 to 6.
it is submitted by the learned counsel appearing for respondents 3 to 6, 3, 4, 5, 6, that affidavit has been filed today. Stop. Registry to trace out the said affidavit stated to have been filed and connected to the case record by the next date fixed. Mr. D. Chakraborty, learned counsel appearing for the petitioner submits that what you want to file a reply.
But,
Rejoinder.
here, there are certain factual.
Do you want to file a
disputes.
rejoinder or not?
To obtain instruction, my lord.
Would like to obtain instructions in respect. Would like to complete his instructions and file rejoinder affidavit if so required. Matter adjourned. For 3 weeks.
Can a date be given, my lord, after 3 weeks?
You first complete your instructions. We'll see. 3 weeks.
My lord, okay.
So this matter pertains to not giving the promotion to the petitioner while he was working under the PNRD department.
Yes, Panchayat, you are supposed to file some affidavit.
That's
Have you filed? It's filed. Yes, it is filed.
The only statement they have produced here in the affidavit of opposition filed by respondent number 2 is that they have given promotion in a post, my lord, which is, my lord, created newly after the applications were forwarded on behalf of the petitioner. But while doing so, the grade pay of the petitioner has been reduced. Earlier, his grade pay was 8,000 per month. Now, after the promotion, which is not even a promotion in the eye of law, my lord, it is a redesignated post. Because I was pursuing for my promotion to the post of account officer, as is availing in the Department of DRDA under the wing of PNRD department. After the amalgamation of the DRDA with the PNRD department, there was an assurance given to us that I will be promoted to the post of account officer. And to that effect, there is a office note also from the, which is availing from the note sheet of the department.
What is your prayer here?
Well, my prayer is that my due promotion, because I am stagnating in the same post in the last few years, while my counterpart in the Department of DRDA before amalgamation has been promoted to the post of account officer. So my prayer in my various representation was only to give promotion to the post I am eligible. Because I joined my service in the 1988 as an account cum storekeeper. And the same person appointed in the under Department of DRDA under the wing of PNRD, one of the wings. Well, they were being promoted to the post of accounts officer. But so far as we are concerned on the establishment of deputy commissioner, though our service prospect and the qualifications were same, but we are denied promotion to the post of accounts officer. So if I may take your lordship, the note sheets of the department after representation filed by us, the note sheet clearly reflects that there was a assurance that after the amalgamation is done of the DRDA, our promotion will be considered, which is available at page 24 of my read petition. The post of accounts officer is not in the staffing together of PRIs as well as good staffs. The account officer are DRDA born staffs. And the prayer of Mr. R. Dhar, this is a petitioner, account cum storekeeper for promotion to the rank of accounts officer may be considered after amalgamation of DRDS to Jila Parishad only as paid for white serial number.
So as on date, you are not, you're working in the Zilla Parishad.
Yes, my lord. Now, my lord. Now, DRDA has been merged with Jila Parishad in the year 2017. So the note sheet reflects that after the amalgamation of DRDA with the Jila Parishad, the promotional prospect to the post of accounts officer will be considered.
You are now working as?
My lord, I am now working as an, my lord, redesignated post of officer, assistant account officer.
Is there a set of rules showing the cadre?
There is two set of rules. This is the typical here.
My only contention is that while promoting in a redesignated post of assistant account officer, while my pay event was kept as it was, but my grade pay was reduced. Earlier, my grade pay was 8,000. Now the grade pay is 7,600 per month. So it's not a promotion as I was aspiring for.
There is nothing in your affidavit as to why his claim cannot be considered.
Lordship, in this matter, N.K. Devnath will appear this
Please call
matter.
him, please call him.
His mother was hospitalized today. So next week's time may be gone.
They said DRDA is an autonomous body.
It was under the one of the wings under the establishment deputy commissioner along with Jila Parishad for a particular purpose. So I was shifted there. I was deputed under DRDA for some time. Then I was called back. I was initially appointed under the establishment of deputy commissioner in the block level office.
Therefore, you are governed by which service?
I am governed by my deputy commissioner's establishment service.
District establishment.
Yes.
Not by the panchayat rule.
Now, since I am working under Jila Parishad, so I will be governed by the district establishment rule. Madam.
They say you are under the panchayat rules. Panchayat and rural development employee service rules.
But they do not dispute my credentials and my prayer made in the various representation, and they have not stated anything against those, my lord. Why I should not be promoted, why my prayer cannot be considered. Only they have said that I have been given promotion in a redesignated post of assistant account officer.
So now what is your next post to which you want to claim your promotion?
Account officer.
And from what documents do you say so?
Well, I am relying on these note sheets given by the department itself, my lord. This is page 23, 24.
Note sheets can't give you a claim to a different post. There must be a set of rules, notifications to say that you are entitled to be promoted. And what rules?
And my lord, some time may be given to go through if there is any rule. To my knowledge, my lord, under the PNRD department, there is no rule or.
Mr. You're Mr.
As Biswas.
S.
Biswas.
Biswas. Learned counsel appearing for the petitioner submits that some further time be granted to complete his instructions in respect of any rules or notifications available which reflects the post to which the petitioner claims his promotion to. MS so-and-so appears for the petitioner, a respondent submits that affidavit has already been filed. Matter be listed after 1 week.
Date may be
8th of September.
obliged.
Please, your lord.
Lordship, this matter pertain to, this is regarding the petitioner's prayer for allowing him to go for another medical board.
Hmm?
Another medical board.
Hmm.
The petitioner had earlier approached his Honorable High Court
Hmm.
in the year 2018 in connection to his unfitness regarding his hearing ability. The petitioner had actually applied for the post of general constable in general duty in the year 2000 in connection to advertisement of
My lord.
2015.
I would like to submit a small thing, my lord. In this case, my lord, affidavit in opposition is not available with me right now. So, my lord, is it possible to get a small?
It is with me, my lord. It has been served to the petitioner. It is with me. Affidavit in opposition. If I permitted, I can give a copy of the.
There's no permission required from the court. You share your copies.
This is the affidavit in opposition. I have got only one copy on this.
No, no,
Absolutely. So, my lord, basically the petitioner has approached this court for the second time now. In the first instance, kindly peruse to page number 33, that is the Honorable High Court's order in the first petition which he had referred it before this Honorable Court, where the Honorable Court had directed the respondent authority to consider his prayer and allow him to appear for re-medical. And as such, the petitioner had appeared, but now what has happened in the re-medical, the petitioner was, he had underwent with the investigation and test that was conducted on 16/2/2021 as per the order dated 26/11/2020, which is page number 33, that is the Honorable High Court's order, the first order. And the operation part was in the last, the second last para. The respondent, that is page number 33. The respondent number 2 shall inform the petitioner of the date when he is required to appear before the medical court, giving him such reasonable time that he can appear before the medical court. As such, the petitioner had appeared, and then again the review medical board report came that he is unfit on the same finding, which was done in the previous report, for which he had preferred the petition for the first time. Now that is in page number 38. That is the
What is the unfitness?
that is regarding he has a perforation in his left ear, and that is having low hearing sensitivity, conductive hearing loss, my lord. So, but when he had appeared before a civil hospital, that is on page number 38, again the report has come. In the report comments in the below section, my lord, the report comments bilateral hearing sensitivity within normal limits with conductive component at low frequencies in left ear. Follow up. Now the petitioner, he is currently still going on with his medical reviews in the civil hospital, and then he has been told from the authority, from the medical professional side, that his ailment could be cured because he has got hearing sensitivity with normal limit. But now coming to the review medical board's report, they had again stated the same conclusion which was given from their side in the first review medical board, which was conducted in the year 2018. So basically, if the petitioner is given one more opportunity, last opportunity, and nothing else, since he was duly appointed, he had all the parameters to qualify for the appointment only because of the fact that he had some hearing inability.
Let us see the subsequent review.
My
Review
lord,
medical.
that is
Hmm.
in the affidavit in opposition. It is there. It is in page number 35 to 32. Page number 44 to 48, my lord.
44. May I read it? My lord. Brief of the review medical examination and finding thereof. The board examined the candidates left ear, that is
You're reading from?
from the affidavit in opposition. And also I have got that one annexed in my,
You take us to the report, review medical board report.
my lord. In my petition, 35 to 37, my lord. Annexer G. In my petition.
Yes.
My lord, that is number 2, brief of the review medical examination and finding thereof. The board examined the candidate's left ear, no distortion, left TM intact, mild hearing loss. The case was further referred for specialist, in brackets ENT specialist, opinion and investigation at Safdarjung Hospital, New Delhi. Number 1, PTA report dated 16/2/2021, number 20243 reveals left ear mild conductive loss. Number 2,
According to you, this is not conducted by a specialist.
at that period of time, since I was examined, I had underwent with the review in Safdarjung Hospital. I had the apprehension that maybe it was conducted from the CISF medical board personnel. And as such, I had preferred one more medical review in another civil hospital. That is in my page number 38. And there I got that it is within normal limit. So there is a bit of discrepancy, my lord. So I have no objections on the finding. Only thing is that if I am given one more last chance, because I am going through that medical procedure, since I had completed that procedure in the first instance, but on the basis of that procedure, the honorable court had decided that writ petition on my favor on the earlier occasion. Now that procedure, it is continuing, my lord.
The medical opinions will keep on varying.
My lord.
Then
So, my lord, that is why since at that period of time,
the forces will not accept civilian medical reports unless you are able to show that it was not conducted by the desired specialist, which is not available.
yes, my lord, totally I agree.
Then
Now, my lord, that is why I pray before the court, my lord, if I am given one last chance.
no, your last chance will depend on your submissions that this review board who conducted the review medical examination did not comprise of the desired specialist.
My lord.
That statement is not available.
My lord, now from the affidavit in opposition, it can be seen that it was conducted by the CISF personnel and then they have referred it to the super specialty hospital.
Then
So, my lord, on that basis, my lord, I maybe just give a last chance.
so
If-
last chance for what?
Just to appear one more time
Before whom?
before the CISF if it is required for last chance.
Why? Why should we keep on troubling them?
My lord, due to the fact that, my lord, I was appointed, my lord, and I had all the other parameters.
No, you have everything, but problem is that this is a finding of a medical board.
My lord.
Where is the statement that Mr. Decca? Where is the statement that it is conducted by the concerned specialist in the review medical board?
Well, this affidavit in opposition is not with me, but I would like to draw the attention of honorable court to page number 44, my lord.
Page number 44.
Page number 44 of affidavit in opposition.
Ah.
There, at the bottom of the page, your lordship will find the members of that particular review committee who have been seated to examine the petition. And these are specialist people, my lord, to deal with this regarding the physical fitness of a particular candidate.
Who are the specialists? He is having some hearing problems.
Yes, my lord.
So naturally, you'll have to have an ENT specialist.
Yeah, my lord, who is the personnel in charge of that, my lord? That instruction I will have to obtain from the department. Who is the specialist in
After
this?
you have filed the affidavit,
My lord,
after you have filed the affidavit,
my lord, affidavit has been filed, but the copy of the affidavit is not available with me. That is the big problem.
that problem you have to sort out.
Yes, my lord. That is
How
entirely my
can we help
problem.
you?
So is it possible to fix, my lord, on Tuesday, my lord? On that day, I can bring the required instruction, my lord.
All right, at the request of Mr. Deka, learned counsel appearing for the respondent who expresses his difficulty to address the court today as the copy of the affidavit filed on behalf of the respondents is not available with him. He prays accommodation for a day. Matter stands adjourned at his request to be posted next week. Mr.
W.R. Mehdi.
W.R. Mehdi appears for the petitioner. Is taken on 30.
Deeply obliged, my lord.
Obliged.
Steps taken.
Lordship, in this matter, we have received the instructions from the department. I may be allowed to file my affidavit.
How many months will it take?
Lordship, I've received it today, Lordship. 2 weeks,
Mr. A.
Fukan.
Fukan, learned standing counsel. You are appearing for whom?
I'm appearing for the elementary education. Department.
Elementary Education Department submits that instructions have been received. We'd like to file an affidavit within 2 weeks. Yes,
My lord, a similar order was passed in a similar case by your lordship. So I pray for that order. A direct.
give us a copy. Let us see.
A direction was issued under Rule 14.
Have you gone through this order?
Lordship, I haven't gone through. Lordship,
You don't have one more copy? Give it to him. You go through, we'll take it up at 2 o'clock. Tell us whether
Well-
it is covered. At 2.
sure. DPM.
At 2. Huh? Yes, who is appearing for the petitioner?
Lordship, earlier Mr. Nair was appearing.
Your pleadings are complete.
Here, Lordship, subsequent to court order, Lordship, dated 4/6/2021, Lordship, inquiry has been completed and the person has been terminated from the post of Vice Chancellor, and that termination has been challenged in another petition. Lordship.
All right, you give the number, we'll put it across.
Yes, Lord.
None appears for the petitioner on call. Mr. B. Chaudhary, learned counsel appearing for the Agriculture Department, submits that pursuant to the order passed by this court on 4/6/2021. Uh, The proceedings have culminated in the proceedings initiated against the petitioner have been completed, and who is to give the who completed the proceedings?
Lordship, the high level.
The high level inquiry committee recommended the
By the government.
termination of the petitioner. You have terminated him.
Yes, Lordship.
He could not have in view of this order.
Lordship, subsequently, he challenged the inquiry report also and the
Come
termination.
to page
also.
number, paragraph 38, second last paragraph.
Yes, Lordship, after following the direction given in this order.
You should have brought it here.
Lordship, there are all total 4 cases. Lordship, let it come together. Lordship, then it will be.
The pursuant to the orders, the recommendations of the high level inquiry committee, the petitioner has already been terminated.
Yeah.
It is submitted that this termination order has further been challenged by the petitioner in a petition being WPC number,
Lordship, I have given that.
WPC number so and so of so and so. Accordingly, let this writ petition, what is the number? WPC number,
Lordship,
no, which writ petition has he challenged?
5815, Lordship.
5815 of 2021.
Yes, Lordship. There are several repetition he has filed in each of the cases, Lordship. All those are still pending, Lordship.
Stop. It is further submitted that by the same petitioner.
Yes, Lordship.
By the same petitioner, several other writ petitions are also filed in connection with the same issue. It is submitted that all these writ petitions be listed together. Accordingly, that this writ petition be listed along with WPC 2985 of 21, 5815 of 21, 3814 of 21, 8177 of 21. List after 2 weeks.
Lordship, I go for respondent number 4.
MS so and so appears for respondent number 4. Yes.
Now in this case, my respondent is not affidavit. The parties to my termination from service. I want to interim my.
No affidavit file.
No affidavit.
Madam,
Lordship, other instruction not received, so need to extend maybe granted.
MS Bora, S Bora,
Bora.
N Bora. Learned counsel appearing for the PNRD. Raise foreign is granted 2 weeks further time, 3 weeks further time to file the affidavit. Stop. Let the matter be listed after 3 weeks. After 3 weeks.
Hello. May I please allow? Well, matter related to compensation amendment. Compensation amendment. Here, my lord, other petitioner, my lord, was died on my lord. 13/6/2005 file in service, my lord. Thereafter, petitioner filed application for compensation amendment, my lord. DLC, my lord, thereafter considered it and sent in 2006 and 7 to the SLC for recommendation for my approval, my lord. But SLC, my lord, in 2014, my lord, rejected the claim of the petitioner only on the ground that there is only 2 vacancy, 3 candidate. His petitioner financial condition is slightly better than other 2. Accordingly, he could not be considered. That was, my lord, in the SLC report, my lord. So I challenge this my SLC order, my lord, on the ground that without any going through any record or within verification any, they have passed this order. Now, my lord, in this regard, the respondent 2 and 3 has also filed affidavit, my lord, saying same, my lord, that his financial condition was slightly better than others. So now, my lord, my limited prayer before Lord is, my lord, now vacancy is available. So let the matter be sent to the SLC for reconsider, my lord. What is my limited prayer?
Where you are challenging what?
My lord, you will also will find page, annexer F, my lord, page 20.
Let us see your prayer first. You are
Yes, sir.
praying for setting aside of the SLC.
SLC, my lord.
Where is the SLC minutes?
Page, my lord, 20. And page 20, my lord.
Page 20.
20.
Relevant.
Relevant portion is page 22, my lord. Paragraph, column, Roman 3, my lord. Second paragraph, my lord. Page 22,
Hmm.
3, Roman 3, my lord. Relevant, second paragraph, my lord. Rubo Kumar Kolita, son of Rajan Chandra Kolita, SC DS Junior, Sonitpur SC Division, who died in harness on 13/6/2025 and applied on 18/8/2005 for appointment on commissioner ground. His application was taken up for consideration for the year 2006 and then again in 2007. The application Dhruva Kumar Kolita had requisite educational qualification of passing HSLC examination and was also otherwise eligible except having better financial condition than other two applications, Kopil Bora and Timothy Bina Das, who were recommended for the year 2006 and 2007 respectively. And the application of Sri Dhruva Kumar Kolita was ranked at rank 3 and rank 2 respectively in the year 2006 and 2007. And hence this application could not be considered by SLC because of having better financial condition than other eligible candidates and storage of vacancy and hence rejected.
So what is the error here? Why do you want to challenge this order? They have considered your case. Financial condition is a ground. So your case was not considered justified. Then
Moreover, Lordship,
Then, because of the
moreover, Lordship, the applied on 2005, approved by the DLC on 2007, rejected by the SLC on 2014. This writ petition was filed on 2021. Now that the principle of die and hardness is not here, Lordship. Delay laxus is there, and therefore, Lordship, it cannot be considered. Delay 2005 application, Lordship. Now it is 2023, Lordship.
What remains to be done,
Yes,
Mr.
Lordship.
Roman?
only for reconsideration, my lord.
Reconsideration
In the
why?
present existing vacancy, my lord.
Huh?
Then, my lord, only 2 vacancies were there.
No,
Were
how-
there. That is why he could not be considered, my lord.
No.
How can he
You have
will
to tell
got the
us
present
how many vacancies are
vacancy?
available now.
No, Lordship, how can he got the vacancy, present vacancy, Lordship? It is
Your claim will not be
yes,
against
yes, Lordship, because
these
NC
vacancies.
Santosh
Your
is
claim is
clear,
against those
Lordship.
vacancies.
Yes,
Because it's not about vacancies being available. It is about the question of consideration of your physical, your hardship, so
Yes,
many other
Lordship.
conditions. They have passed a fairly elaborate order, SLC. Unless you want to point out that these conditions are not supported by the correct facts, we see no reason to interfere.
On the other hand, my lord, in this regard, my lord, respondent number 2 has on 3 has also filed an affidavit, my lord, stating some financial position of the petitioner, my lord. In this regard, I have no, my lord, any clarified from the, my lord, petitioner. So later, after 2 weeks, in the meantime, I will also take instruction from the client whether it is documents which have been annexed by them, my lord, is, if it is correct, then, my lord, all right.
It is correct. What instructions will he give?
But regarding financial status, well, his
Financial status, if he is in difficulty, he has to show us.
financial
that is
status,
a-
Lordship, at that time, Lordship, not this time, Lordship. The present time. That time, it means on 2007, Lordship.
Then that is up to your lordship. Only by no vacancies available, complete.
No, no, now
Even
present
No,
vacancy.
that can be done just like that. Just for the asking, it can be done. Unless you satisfy that, yes, this order did not take into consideration the relevant conditions of the OM or did not take into account the correct facts. It can be done merely because you want to take a chance now. We'll close it, giving you liberty if you want later. All right? Heard learned counsels for the parties. This writ petition has been filed by the petitioner, praying for consideration for compassionate appointment under the die in harness scheme. Stop. Petitioner's father
Father.
who was serving as a soil conservation demonstrator within bracket junior under Sunitpur Soil Conservation Division, Tejpur, expired on 13/6/2005. While in service. Pursuant thereto, the petitioner filed an application seeking compassionate appointment. It is the submission of the learned counsel for the petitioner that his name was recommended twice by the DHC for the year 2006 and 7 and forwarded it to the SLC. Stop. Since no orders were passed, he had approached this court earlier by filing WPC 388 of 2012, seeking appropriate directions. Stop this court by order dated 18/5/2012 disposed of the writ petition directing the respondents to consider the case of the petitioner in the light of the judgment rendered in Achyut Ranjan Das versus State of Assam, reported in 2006, Volume 4, GLT 674. Stop. Meanwhile, the petitioner also obtained his graduation from Krishnakanto Kondikoi State Open University. Thereafter, the SLC by minutes, SLC in its meeting held on 18/12/2014 rejected the case of the petitioner, stating that the financial condition of the petitioner, rejecting the case on the rejecting the case of the petitioner on the ground that his financial condition does not require consideration by the SLC. Stop. Being agreed, the present writ petition has been filed. Have you filed your replies?
My lord, I have filed my affidavit, my lord. Respondent number 2, 3, and 4, my lord.
Para respondents 2, 3, and 4 have filed their affidavit in opposition. 2, 3, and 4.
Soil conservation department. On 14/6/2023, I have filed my additional affidavit where the petitioner is the better financial condition, my lord, I have annexed.
Respondent number 2 has filed, 2, 3, and 4 has
Yes.
filed their affidavits contesting the claims of the petitioner. Stop. An additional affidavit has also been filed by the said respondents. Petitioner has also filed an additional affidavit to bring on record certain documents. What is that?
Annexer X pay running page 50, my lord. Where my lord.
What is
petitioner-
that annexure 9 of your additional affidavit?
Annexure 9, my lord, that is, my lord, the table form, my lord, where the petitioner has, my lord. The other, my lord, the other Kokil Bora and Bina Bora, my lord, they are, my lord, they have only one katha, Kokil Bora, one katha land, my lord, and Bina Bora, he have no land, my lord. My lord, their financial position is.
But the petitioner is not considered here, is he?
Yes, my lord.
Has it been considered?
No, my lord, it is that, my lord, annexure 10, page 50, my lord.
No, you come to annexure 9
Yes,
of your additional affidavit.
Yes, ma'am.
Why have you enclosed this bunch of papers? What is the name of the petitioner?
Rupa Kumar Kolita, my
Rupakumar Kolita.
Rupa Kumar?
Kolita.
lord.
By the said additional affidavit, a communication dated 17 October 2022 is being brought on record to show the financial status between the petitioner vis-a-vis two other claimants. Stop. The petitioner has been shown to have received gratuity pension, GPF, family pension, and as well as are shown to be landholders as compared to the other persons, other claimants. Stop.
My lord, sorry to interrupt, my lord, page 49, my lord. That is, my lord, petitioner, my lord. Above, my lord, Prasanta Sharma. His father name Rajendra Chandra Kolita. This is one big regarding petitioner.
You come to the last page,
Yes, ma'am.
annexure 10.
Yes, ma'am.
This is the financial position.
Yes, ma'am.
There are the SLC by its meeting held on 1/12/2014. Stop. has considered the case of the petitioner, and the following conclusions drawn by the SLC in its meeting are extracted below. Page number 57, serial number Roman 3, the whole paragraph. Extract. Learned counsels for the parties have been heard, pleadings on record have been carefully perused. It is seen that the pursuant to the recommendation of the DLC, the petitioner's case was considered by the SLC. The SLC has considered the financial standing of the petitioner's family and has taken a decision not to recommend the name of the petitioner in view of the financial position of the petitioner. Stop. The on these considerations, the petitioner's application was placed at serial number 3 as compared to the other claimants. Stop. Learned counsel for the petitioner has not been able to dispute these findings by bringing on record any documents to contend that these findings were not based on correct appreciation of the facts. Stop. Learned counsel for the petitioner has also not disputed the financial status as reflected in the communication dated 17th October 2022, issued by the Department of Soil Conservation, Government of Assam. Stop. The only consideration, only prayer made by the learned counsel for the petitioner is that vacancies being available, petitioner's case should be remanded back to the SLC for being reconsidered again by the SLC in the face of the vacancies stated to be available. Such submission cannot be accepted in view of the law laid down in Achyut Ranjan Das and Porizun Nessa and all other judgments and orders passed by this court, read with the OM dated 15/6. When did your father expire?
2005, Lordship.
13/6/2010.
So that time, what was the OM?
OM 2000,
2009.
2009, 2000, before that, his father was died. 2005, he was
He
died.
died.
Lordship.
Then
In 86, I think, 1986.
The relevant OMs prevalent at the relevant point in time, read with the OM dated 15/6/2015, presently laying down the guidelines for consideration of the cases for compassionate appointment. Stop. Unless there is a dispute, unless it is disputed by the petitioner that the facts based on records, that the position reflected, stated to be based on records are not correct, or that the provisions of the OM dated so and so, read with the judgment of this court, rendered in Achyut Ranjan Supra and Porizun Nessa Supra, have not been complied with. No case is made out or issuance of directions or orders by this court. But in view of this, above, the writ petition stands dismissed as being devoid of any merit. Interim order, if any, stands vacated. However, liberty is granted to the petitioner to approach this court if any of the findings arrived at by the department are found to be incorrect. We are giving you a liberty in case you want to come back with finding. Otherwise, we don't find any case. Sorry, you have to come back with a better case. 83 earlier, office memorandum 83. On record. Huh? Relevant memorandum being office web paper 83 and other side.
May I please, your lordship? In this case, lordship, private response 6 was appointed by the respondent without following the due procedure of law. According to the petitioner challenged the appointment of the respondent number 6 by filing a title suit. Title suit was dictated and Lani Civil Court cancelled the appointment, set aside the appointment of the petitioners. Their appeal was filed, that was dismissed. Subsequently, the respondent did not take any steps for further advertisement for appointing other persons. That's why we filed the instant case. On receipt of notice,
Who is the decree holder? You.
I am the decree holder.
Then
Then on receipt of notice by the respondent's lordship, they have cancelled the appointment of the respondent number 6. And respondent 6 filed a writ petition challenging the cancellation of appointment. That is also pending. Both the case may be taken together, lordship.
no, why? You have a degree in your favor.
Yes, lordship. Subsequently,
So go and pursue that remedy.
yes, but here is the another
have-
similar case
we
is
have
my
already
learned friend.
filed
He filed
RSA.
another writ petition.
We have already challenged that decree by way of regular second appeal. Lord.
Then what happened?
The second appeal is pending, but
There is no stay.
no, lordship. Notice was issued in the state.
Then there is no stay.
Lordship,
It is for them to pursue.
lordship by.
What has a writ court got to do with it?
Lordship.
And my learned friend also filed a writ petition. That is not listed. Both the matter
Why, what writ petition?
against cancellation of appointment.
Then
Both the matter be taken together.
you want both petitions to be dismissed on the same day.
My,
All right.
I want my case may be allowed, her petition may be dismissed.
How?
Lordship, I
You're not happy with a decree of the title of the trial court.
decree in my favor. Lord.
So you want now an order from the High Court. You want to frame it.
Certainly, but there is no provision regarding the.
It is
execution
submitted
procedure
that
service matter.
similar
That is the problem, Number-
writ petition being WPC number
2276
2276
of 2023.
of 2023 filed by the respondent as
Number
a
six.
petitioner. Respondent number
6.
6 as a petitioner is also pending. Both the writ petitions be connected together. Do you agree or dispute with the prayer?
Lordship, that is in regard to cancellation of my service, Lordship. And this.
For the same center?
This.
Same center.
Yes,
For the same center?
yes, Lordship. And this writ
Arising,
petition I have
relating
raised-
to the dispute of appointment of Anganwadi worker in the which center is it?
In the 98 number, Congress Center number 98, attached with 42 number Dasgram Model LP School. At W Center 98,
Center number 98, Anganwadi Center of Dasgram village
Dasgram.
in
LP
the
School.
district of Karimganj.
Yes.
I have filed my affidavit in opposition.
Attached to the Dasgram number 42 Dasgram Model LP School. Let both the writ petitions be listed on 30 August.
In that writ petition, service is not complete, Lordship.
We'll try to dismiss it.
My writ petition, Lordship, without, they have not appeared, Lordship, in that writ petition.
If we allow it,
Lordship.
then there's no problem.
No, Lordship.
So let us see what we can do on 30. 30.
Yeah, no? Okay.
Obliged.
Government councils. নাম কেটা লইল Yes.
Made resolutive on the basis of the order dated 35/23, my lordship, matter is pending before the mediator. And one mediation report is there for, today is the date for final settlement, my lordship.
It is one mediator report may be seen. Mediator has one under 1 month time. I think. Totally, it may be given, my lord.
Seen the report submitted by the Guwahati, the report of the mediator submitted by the Secretary Guwahati High Court Mediation Center, whereby it is submitted that the mediator prays for 1 month's time to 1 month's further time to conclude the disputes referred. Learned counsels for the parties are present. Matter be deferred,
1 month.
listed after after 1 month. List on 29th of September, 29 September.
Wait to your lordship. Lordship, in this case, lordship, I have basically challenged that gradation list, lordship. But after an interim order was
Provisional
passed-
gradation list.
provisional gradation list, after the interim order was passed by this honorable court, the gradation list has now been released, and we have been placed at the top. So basically, this writ petition, the grievance in the writ petition has been met up. lordship.
Mr. P. Decca, learned counsel for the petitioner, submits that the grievance of the petitioner was, the challenge in the writ petition was to the gradation list. Draft
Gradation.
gradation list, which was published
Published on.
by communication bearing number so and so dated 5/1/2015.
Yes, sir.
No. What is the draft gradation list?
Lordship.
30.
On 5/1/2015. And lordship, my impugn letter was 8/2/2021, whereby what has happened in this case, they have stated that I have foregone promotion, and that is why my name was kept at the bottom of the list.
Mm,
May I please, your lordship. My lord, in the meantime, this petitioner number 1 and 2 has been promoted, my lord.
Yes. Yes.
Lordship, may I go
draft
to this order?
gradation list, challenging the communication dated 5/1/2015 and as well as the draft gradation list,
And
provisional gradation list dated 30/07/2021 and communication dated 8/2/2021.
Yes, sir.
Stop. This court by order dated
2/9/2021.
2/9/2021, while issuing notice, had issued an interim order. Stop. Mr. S.P. Das, learned counsel, appears for response. 1,
5, my
2,
lord.
Huh?
5, my lord.
only 5.
Yes, sir, only 5.
Who appears for 1, 2, and 3, 4? Mr. J.K. Goswami appears for respondents 1, 2, 3, 4. Who's for 6 and 7?
No, they have not appeared. 6, 7, 8, 9.
Respondents 6, 7, 8, 9 have not appeared. It
After
is submitted by the learned counsels for the petitioner as well as for the respondent number 5 that pursuant to the notices being issued by the court, the final gradation list has been published where the names of the petitioners are placed at serial 1 and 2 and
1, 2, 3, and 4.
1, 2, 3, and 4. No, how many petitioners are there? 4. Okay, 1, 2, 3, and 4. And petitioners 1 and 2 has been promoted in the meantime
Yes, my lord. To the post of superintendent,
to the post of superintendent.
GECT.
Give us a copy if you have.
My lord.
To the post of superintendent under the Assam Directorate Establishment, sorry, to the post of superintendent
In the office of, my lord.
in the Office of Skill, Employment, Entrepreneurship Department, Government of Assam.
DECT, my lord. In the Directorate of Employment and Customer Training.
What is that?
My lord, that is number 5, my lord. Office of the Directorate of Employment and Customer Training.
They are promoted as superintendent in the Directorate of Employment and Craftsman Training under the Skill Employment and Entrepreneurship Department, Government of Assam. Stop. Under such circumstances, learned counsel for the petitioner submits that the grievances of the petitioner has been ameliorated and therefore no further cause survives
Only liberty may be granted in case.
to pursue the writ petition. Copy of the communications showing the promotion of petitioner 1 and 2 as furnished before the court by Mr. S.P. Das is retained in the case record. Stop. Writ petition accordingly dismissed as not pressed. Liberty, however, is granted. Interim orders, if any, stands vacated.
Highly obliged. Obliged.
Twenty-six lordship, in this matter, the petitioner lordship, while working as assistant accounts officer lordship, he was made to discharge the function of accounts officer lordship in charge. That order lordship will find at page 30.
Yes.
So let's kindly come to page 30. Now, so his claim in this writ petition, may I read page 30, Lord?
Yes.
In the interest of the public service, Sri Faizur Rahman, Assistant Accounts Officer, Dibrugarh Division, Assam Urban Water Supply and Sewerage Board Division is hereby allowed to hold the charge of Accounts Officer temporarily of Dibrugarh Division, Assam Urban Water Supply and Sewerage Board in his existing scale of pay as Assistant Accounts Officer and not with charge allowance in addition to his own duties with immediate effect and until further order. And since then, he has been regularly discharging function of Assistant Accounts Officer in charge. Now, in the writ petition, his claim is lordship to grant him regular promotion to the post of Accounts Officer. And lordship, my latest instruction is that lordship, a DPC has also been conducted in the meantime, very recently, for the post of Accounts Officer. And in that DPC, he has been recommended and his case has been approved. But perhaps, lordship, because of this case, lordship,
We close it.
but lordship, difficulty is that
We'll
for
give you
others,
liberty. We'll give you liberty to come back if you want.
but no promotion order has been issued in our case.
It is your submitting because of this case is not been favorably considered.
Perhaps. No, but there is no direction or stay from this honorable court to not issue any promotion order in his case, lordship. So, lordship may at least, they have not yet filed any reply also. So lordship may at least observe that pendency is no bar to give effect to the DPC minutes.
Who's for the respondent? Urban Water.
Lordship, the Standing Council of Urban Water.
Who is there?
Urban Water and Storage Board. No?
We'll direct and what is your prayer here?
Prayer lordship, our prayer is from, we are claiming from the date of vacancy or date of our eligibility. Lordship will see page 18. Prayer B. A writ of mandamus or
No,
any
the
other.
prayer A.
Prayer A, lordship, a writ of mandamus, certiorari or any other appropriate writ order. that-
No, prayer A.
A I am reading, lordship. A writ of mandamus, page 17.
Page 18.
Directing or commanding the respondents to pay 8,000 to 3,500 with GP 4600 with effect from 14/3/2011.
This is area as what?
Lordship, the from the date we discharge the function of accounts officer in charge. So we claim for the pay scale of accounts officer.
I heard learned counsel for the petitioner. This writ petition has been filed by the petitioner, who's praying for release of the amount he is entitled to with grade pay with effect from 14/3/2011 and from the date of implementation of ROP 2017 along with arrears for as the petitioner has been continuing to work as assistant accounts officer in the regular vacancy of assistant account officer in the Jorhat division of the Assam Urban Water Supply and Sewerage Board as a stopgap arrangement. Stop. The petitioner is in a substantive post of LD assistant cum typist under the said board. Stop. Since 12/11/2002, petitioner has been rendering his services as assistant accounts officer as stopgap arrangement. You're still working?
Still working
It is the submission of the learned counsel for the petitioner that
as account officer in charge. Still
what is the order at page 24? You are regularized.
yes, regular. Sir. Regular.
Subsequently, by 14/11/2008, the petitioner has been regularized as accounts officer, assistant accounts officer in Assam Urban Water Sewerage Disposal and Supply and Sewerage Disposal Board. Stop. The petitioner was thereafter transferred and posted
Dibrugarh
in
to Dibrugarh.
Dibrugarh division. By order dated 14/3/2011, the petitioner has been further allowed to hold charge of the accounts officer temporarily in the Dibrugarh division of the board. Stop. The petitioner, having rendered his services as accounts officer in charge with effect from 14/3/2011, represented before the competent authority seeking you are seeking for upgrading.
But this representation is old one, 2012 representation.
Sought for regular prayed for necessary orders for being regularized in the said post of accounts officer of Assam Urban Waters and Sewerage Disposal. Stop. Sewerage Board, sorry. In page number 35, where is your seniority position?
Number 2, Lordship.
Learned counsel for the petitioner refers to the notification dated 27/10/2020, whereby the petitioner is shown to be at the serial number 2 in the gradation list. However, the prayer of the petitioner seeking regular promotion to the post of accounts officer of under the Assam Urban Water Supply and Sewerage Board has not been attended to. Stop. Petitioner preferred a representation dated 25/01/2021, ventilating his grievances. However, the same has also remained unattended. Stop. Aggrieved, the present writ petition has been filed, praying for adequate orders by this court. Era. notices were issued on 9/9/2021. However, no response has been filed by the respondents. There is no office note indicating whether steps have been taken by the petitioner in respect of the private respondents. Stop. The respondents are also not represented today when the matter is called up. During the course of the hearing, Mr.
There's no
Sharma,
private- There's no private response.
have you taken steps or not?
I have taken.
The Mr. Sharma submits that the petitioner's case is presently under consideration, and from reliable sources, he is informed that his case is likely to be considered favorably for regular promotion to the post of accounts officer. Accounts officer.
Accounts.
Stop. DPC has already been undertaken.
Yes, I have the minutes of the DPC.
Very well. Show us. Give us a copy.
Lordship may see, I have only one copy. Lordship may see page 4. There are 3.
The learned counsel for the petitioner has procured a copy of the minutes of the 59th Board of Directors meeting held on 19/10/2022, wherein the case of the petitioner has been given due approval for promotion to the post of accounts officer, along with other similarly situated candidates. Stop.
And
In that view of the matter, yes,
promotion orders of other candidates also I have received.
he has also relied upon, he has also referred to the promotion orders issued in favor of the other similarly situated candidates
These are dated, their names are also been
whose
recommended.
names have been recommended
May I
along with
give the
the
names?
petitioner. Stop. Learned counsel for the petitioner submits that there is an apprehension that because of the pendency of the writ petition, promotion orders have not been issued in his favor. He further submits that since his case has already been considered for promotion, the department has attended to his grievances raised before the writ petition, in the writ petition. Except for release of area.
And Lordship, there, my prayer, Lordship, in B, against B, Lordship, is with effect from the date of vacancy or
With regard to the release of areas and what seniority.
no, Lordship, my prayer is to give effect to the my promotion as account officer from the date of vacancy or on attaining my
But
eligibility.
your promotion order is not yet issued.
Not yet issued. But for others, Lordship, they have issued it prospectively, Lordship.
Let the order come.
Let the order.
Under such circumstances, this court is of the considered opinion that the writ petition can be closed since the prayers made by the petitioner has largely been attended to by the department, as is reflected from the minutes of the Board of Directors meeting held on 19/10/2022. Stop. In that view of the matter, the writ petition stands closed. It is expected that the Board of Directors will issue necessary promotion orders in pursuance to the resolution adopted by the Board of Directors in favor of the petitioner, as has been done in the case of other similarly situated persons. Stop. Any other grievance which the petitioner may have in respect of release of arrears or in respect of giving effect or in respect of his seniority, etc., can be addressed by the respondent authority upon such representations being filed by the petitioner. In terms of the above, writ petition stands closed.
Promotion order to be issued, if any, within a time frame.
We are requesting them. That's all we can do. Liberty is granted to the petitioner in the event the liberty is granted to the petitioner.
They might keep it pending, Lordship.
So we are giving you liberty.
Obliged.
Item.
Lordship, I am on behalf of Mr. Amsoika. Learned counsel is not present here before due to his personal difficulties. Therefore, Mr. may kindly be taken for that.
What is his, what have you done with his claims? What is the department stand?
Lordship, will take instructions
Instructions.
and file of the deputy.
Very nice. At joint request, matter stands adjourned for 2 weeks. Meanwhile, the departmental council will endeavor to file necessary
There is another
counter
matter.
affidavit.
There is another matter, item number 29.
You wait for that matter.
Yes.
None appears.
Lordship, matter become infractuous because Lordship, he was transferred to Lordship Cobra Mohila Battalion in the Medinapur, West Bengal. He has already joined Lordship. In 2021 itself, he has joined Lordship.
There was no interim order.
No interim order, Lordship. He has joined Lordship. Even in the petition, Lordship, they have prayed for she will go to voluntary retirement. That representation also withdrawn by the petitioner herself, Lordship, and she wants to continue in the department as a head constable in the CRPF Mohila Cobra Battalion, Lordship.
None appears for the petitioner on call, Mr. K. Gogoi, learned standing counsel, CGC.
Lordship.
Appears for the respondents. Stop. This writ petition is filed by the petitioner challenging the transfer order
Order dated 19/8/21, it page 16, Lordship.
19/8/2021,
Yes.
whereby the petitioner who was transferred from
From Lordship, Khotkhoti CRPF Group Center, Khotkhoti, Karbi Anglong to Lordship. 232 Mohila Battalion, West Medinapur, West Bengal, Lordship.
she was transferred from a present place of posting, which is group, what is that?
Group Center,
Group
CRPF,
Center,
Khotkhoti,
Khatkati, CRPF,
Lordship.
to
2 Lordship,
232 Mahila Battalion
Mm.
at Medinapur in West Bengal.
Lordship.
Stop. This court, by order dated 5/10/2021, had issued notice. However, no interim was granted. Stop. This court directed that pendency of the writ petition would not be a bar for the respondent authorities to decide and dispose of the representation of the petitioner, which was pending before the authority.
That was withdrawn, Lordship, petitioner herself. I have the record.
It is submitted by Mr. Gogoi that the representation was withdrawn
Lordship.
by the petitioner herself, and pursuant thereto, she has proceeded to join. in a
Before that,
place-
she has proceeded to join. After joining Lordship, she has withdrawn the
and she has proceeded to join in her place of posting, which is 232 Mohila Battalion, Medinapur, West Bengal. Under such circumstances, nothing further survives to be decided in the writ petition. Do you have any
Lordship.
letter?
I have the copy that where representation was withdrawn, Lordship.
No, the joining.
Joining, I have the order, Lordship. I have the relieving order.
Serial number 11.
Lordship.
The learned counsel for the department submits that the relieving order dated 5/1/2022, relieving the CRPF, this is CRPF,
Lordship.
CRPF personnels, including the petitioner, enabling them to join in their respective place of posting is reflected here.
Next one is
Is produced before the court. The name of the petitioner appears at serial number 1 in the copy of the relieving order dated 5/1/2022. Stop. He has also produced a copy of the order
29 December 21, Lordship, whereby CS
29 December 2021, whereby the petitioner withdrew her application pending before the authority. Copies of these communications are kept on the case, in the case record. Stop considering the submissions made by the learned counsel for the petitioners, for the respondent, and on due perusal of the orders placed before this court, as well as the writ petition, as well as the averments made in the writ petition. This court is of the considered view that the petitioner, having complied with the order dated 19/8/2021, transferring the petitioner from Group Center Khatkati, Group Center CRPF Khatkati to her new place of posting, has been complied with. Therefore, nothing survives in the writ petition to be decided. And accordingly, writ petition stands closed. No order is to cost.
They have furnished the select list, but that marks what my lord, otherwise the shortlisted candidate, what marks they have obtained. Probably they have missed that part. I can place that also, my lord, so may grant me further time, my lord. Communication has been made already.
That is what is necessary.
Yes. But my lord, they have stated that this was public. Two lists they have furnished.
His grievance is that
Skill
It-
test, my lord.
it is not a,
Particularly,
is your name reflected here?
Roll numbers will be there, my lord.
Petitioner's roll number?
yes.
It will be there, my lord. He was called, my lord.
Yes.
What is his roll number?
Roll number to question. My lord.
Malad 52, sorry, at page 16, my lord, page 16, my lord, at serial number 52, at the bottom, just above the bottom para.
Yes, your name appears, your roll number,
Serial number.
This is a serial number, and the, my lord, the,
0081.
yes, my lord, page number 26, my lord, 0081 and 10151, my lord. These two are.
This is for driving skill test.
My lord.
You appear.
So particularly contained the driving skill test that was done by the MPI, and each of the tests, my lord, contain the signature of the candidate also, my lord. If they produce that record, my lord, that will only show the.
They're not denying, your roll number appears here. You have been called for,
My lord.
but you have not been declared successful. They did not like your driving. Either you're driving too fast or too slow.
Let them produce the merit.
When can you give the records? The what exactly, how the,
My lord, next Friday. Within 7 days I will have time.
Mr. Gogoi, learned standing counsel, Department of Finance, has produced a copy of the notice shortlisting the candidates for appearing in the driving and skill test, along with the select list. Stop. However, the relevant particulars as to how the merit position was arrived at by the department vis-a-vis the candidates who had appeared before the competent authority in response to the advertisement dated 03/09/2020, has not been produced. Stop. Mr. Gogoi prays for further time.
On first,
Uh, he submits that the further 1 week's time be granted to him. Mr. M.A. Islam appears for the petitioner. List on 8th.
8th, my lord, let it be on 8th.
8th.
All right.
Say,
Yes.
my lord, what he submitted in the morning, my lord, that I fall under the memo number 2009. It is already been superseded. And lordship, can you peruse the
No,
OM?
no. Superseded, yes.
No, that case is a latest case, dear lordship. It was passed in 7/12/2022.
Yes, sir.
So as per the earlier memo, what is the requirement?
Lordship.
As per the
2009.
earlier 2000.
2009, lordship, it says that 5% is the 5% is the vacancy highest. Then if there is one post, then that should be given to the compassionate appointment. So that case, lordship, that is settled.
Nikhil.
One
One post is there, my lord. It is
One post has been already given to somebody else. Paragraph 8, your lordship may peruse.
It will be also.
Mm.
I have not gone through it.
Yes.
Paragraph 8, lordship, I'll just read out.
Hmm.
In the instant case, however, it would be seen that both the date as well as the date of filing of the application was done prior to the coming into effect of the memorandum dated 1/6/2015. And the relevant office memorandum at that point of time was the office memorandum dated 2/3/2009. Under such circumstances, office memorandum dated 2/3/2009 is to be made applicable in case of the petitioner. The learned counsel for the petitioner has also drawn attention to the court to para 1 of office memorandum dated 2/3/2009, which is extracted below. The state government had adopted scheme wide OM number so and so dated 9/9/1983 as amended wide number so and so dated 23/3/1992. So and so dated so and so notification dated so and so dated 11/10/2006 to give appointment on compassionate ground to the widow or son or unmarried daughter or adopted son, adopted unmarried daughter of a government servant who dies in harness with the view to give immediate financial assistance to the family of deceased in class 3, class 4 post, limiting such appointment to 5% of the vacancies occurring in a year. The restriction will, however, not apply where only one vacancy is to be filled up in a year. Thus, the department can appoint one person on compassionate ground, again 5% quota up to 20% vacancy in a year. In terms with the office memorandum, although reservation on account of compassionate appointment was limited to 5% of the vacancies occurring in a year, but it was mandated that said restriction will, however, not apply where only one vacancy is to be filled in a year. And as such, a department can appoint one person on compassionate ground, again 5% of quota up to 24% for the vacancy in a year. So what lordship here it was decided is that the OM which was there at that point of time when the date occurs, that will be taken as the OM. So now in this case, lordship, what has happened is that the person died in 2005. His case was initially considered in 2013.
Amit Srivas does not lay down that law,
So,
subject to correction.
lordship,
Amit Srivas
Yes,
The judgment of the apex court
here lordship, I mean, they,
did
yes,
not go into this aspect of which,
yes, that was not discussed there. So that, Justice Borua has discussed this in this,
so you'll have to be examined. You go through and tell us if there's any, this judgment you can go through and
Yes,
come
my
back
lord.
before the court.
And they have stated in the affidavit also that Navajyoti Burman was recommended to the state, to the state government for appointment and compassionate ground for the post of grade 3 junior assistant against one vacant post in the district level committee meeting held on 30/3/2020.
Now, why the reference to the earlier?
so lordship, what has happened is that
Hmm.
this Navajyoti Burman, the petitioner, he was actually recommended in class 3 category. But in the this thing SLC, his case was considered in the category 4. So in the category 4, somebody else was given. So his case was not considered in case 3, grade 3. So later on, again, that's why his name was sent to the SLC. But in that SLC, there was another person who was also recommended. The other person was given. So that is like 2020 SLC.
No. Why is the question of which OM is applicable has a reason?
Because 15 MO, but because their contention is that 15 OM is there.
Ah.
So in for 15 OM, it is stated that if that particular department doesn't have vacancies, they can
According to you, which OM? According to you, which OM?
according to, because of this case now, the OM 2009 will be applicable.
2009 did not have.
So 2009, there is only one vacancy was there. So
No. 2009 is that provision akin to clause 15 is available.
it's not there. It's not there.
It is not
It
there.
was not there.
So I think,
But on 15.
do you have the
11, it is,
judgments?
Earlier OMs have been superseded, my lord, on 15.
Madam, you're not realizing what. Do you have the judgments of Achyut Ranjan and?
Yes.
Yes, let us have a look.
The problem is that Achyut Ranjan did not discuss
earlier
this
I
point.
approached this honorable court,
No.
my lord. I approached this honorable court earlier also and
Mm-hmm.
after an order, my lord. In spite of that, they have accommodated to some other person, my lord.
No, because your claim, there is no vested right in a compassionate appointment.
Yes, my lord.
Your position will have to be found out from the details.
And he said that my name is shown as a grade 4, my lord. It is not my fault. It is their fault because I am applied for grade 3, my lord, and they should have been send me to the as a grade 3 instead of my place, my lord. Someone is accommodated, my lord, and I have obtained a court order also. In spite of that, they have.
Why grade
accommodated to
3?
see-
Why she
Yes,
was
my
not
lord.
considered
It
in
is
grade
their
3?
fault, my
So
lord.
lordship, what has happened, that the mistake was realized and
Ah.
then the case was again placed before the
It
SLC
is a
in
contempt of court,
2020.
my lord.
Then when it was placed before 2020, there was another candidate got it. The same thing.
No. Another candidate means there was some direction from the court.
Yes, his case was placed before the SLC because of that. So then
No,
there
not
was
second time, the first time.
the first time there was no court order. Like second time only there was court order.
First time she was recommended for grade 3,
Grade
Yes.
3.
Like
but SLC considered her for grade 4.
4.
four.
What is the reason given in the?
There was a mistake that so there was some communication that has been annexed by her also. That is there in the petition. There was some mistakes happened. So that's why department again send a name.
And in this particular case, it is considered for grade 3.
Grade 3, my
Grade
lord.
3, grade 3. Grade 3 it was considered, but like there was no vacancy as such, so it was rejected.
So you go through the judgment, madam.
Yes, my lord. My lord.
You address your arguments accordingly if
Yes,
you
my
want.
lord.
There is a coordinate bench which says that the guidelines which prevailed at the time of the death will be applicable.
Thank you, lord.
Heard learned counsels for the parties, the matter is deferred to enable the learned counsel for the petitioner to peruse the judgment dated
7/12/2022.
7/12/2022.
Passed in
Passed
WPC
in
number.
WPC 1914 of 2020, which according to which it was held that the guidelines prevailing at the time of the death of the employee are the guidelines which are to be applied. Stop. Matter will be listed after 1 week, enabling both parties to apprise with the relevant
Yes,
judgments of the
yes.
court. List again after a week.
Early applies. After 2009.
Who's for the respondents?
My lord, in this case, my lord has already passed an order, my lord.
That is the whole purpose why the matter was deferred. It was for the education department, yes.
Lordship, I've gone through the order. Lordship, as saying we can dispose it of Lordship.
All right, heard
as
that
per
counsels for the
section 15.
parties, matter stands disposed in terms of this order.
Upon due verification.
16/8/2023. Disposed.
Deeply available.
I'm on behalf of Mr. M. Soikia. Make council is put on.
When was the matter, earlier matter adjourned?
27.
Our matter, which was the earlier matter?
27. Item.
27 get it. Matter will be listed after 2 weeks at the request of learned counsel for the petitioner.
I apologize, my lord. My lord, I was on legs in code number 1 when item number 20 was called, my lord. My
We have
lord,
passed some order.
my lord, non-appear has been passed, my lord. I was on legs, my lord. I was in the code.
So if you're not, nobody appears, then nobody appears.
My lord, may just non-appear may be removed, my.
Deal with it. Will come after 2 weeks.
My lord, the non-appear may be removed. Because out of
Mr.
that,
Sharma appears before court number so and so.
no, my lord. If it can be, my lord, just record.
After 2 weeks.
Much obliged, my lord.
Item 20.
So it is that reservation in promotion,
Yes.
the division bench has come. The lordship may fix it for disposal on a hearing day.
What did the revision mean? What is the order? Judgment.
Now,
That will require some examination.
my lord, my case is otherwise very simple. Admittedly, my lord, I stand senior to him in
No,
the.
simple or complicated, we'll have to understand, keeping in view the judgment of the division bench.
My lord, the division bench judgment is available, my lord. I can place it before your lordship. Now, the judgment of the honorable single judge was primarily concerned with the aspect of consequential seniority so far as the 2002 circular office memorandum is concerned, and the effect of clause 4 of the 2016 circular, amongst the other things. Now, the honorable single judge had given a finding that 2002 office memorandum is holding the field. That has not been diluted in any manner. And the particular finding so far as the clause 4 of the memorandum is concerned, 2016 memorandum is concerned, the finding is that is only in the nature of a clarification provided to the scenario post the amendments in the constitution. These two aspects were also highlighted before the honorable division bench, and these aspects have not been disturbed. These findings have not been disturbed, as I have understood. Now, apart from the aspect of whether the question of consequential seniority will come or not, the case of the writ petitioner is that he stands senior to the private respondents in all the grades, in all the feeder cadre as such. And therefore, while considering the promotion to the post of additional chief engineer, his seniority ought to have been taken into account because of the fact that he stands senior to the private respondent. And the finding of the DPC was that since merit of all the persons were equal, so therefore he ought to have been considered for the purpose of promotion, and the promotion ought to have been given, which has not been given, relying on that particular clause 4 of 2016 memorandum, because in the past the petitioner earned accelerated promotion. So that is the case. Now, regardless of the fact whether the question of accelerated promotion will come or not, prima facie, my lord, my submission would be
since it was a case of promotion based on merit cum seniority, and there was a finding by the DPC that merit of the parties were equal, on equal footing, naturally the seniority of this writ petitioner ought to have been taken into account. And the seniority of the petitioner has not been challenged till date. It has it is all along, right from the time when he was executive engineer in the department, my lord, the private respondent stood junior to him in the seniority list.
And in the claim of the respondent is that because of that,
Claim of the respondent is that
because of accelerated seniority.
yes, because of accelerated seniority, I should not get it. It should go to him.
The claim of the respondent is that at various stages, first that 2002 OM comes, if your lordship goes by the sequence of events, then in 2006, Nagraj is delivered by the constitution bench. After Nagraj, there is a mandate that unless there is quantifiable data in existence, there cannot be. Catch-up principle is automatic. Right? There are several judgments which I'll place during the course of the argument. Now, also, that position was never correct. So finally, when I was promoted as additional chief, this is one of the aspects that weighed in the mind of the selection committee, and that is how I was given. But irrespective of what the challenge is, there has been an intervening further development. In the meantime, about a few days back, now the challenge here is to my promotion as additional chief engineer, and thereafter as chief engineer, only this selection is under challenge. Even the final order has not been put to challenge. In the meantime, he has been further promoted as secretary. That aspect, perhaps without a challenge, I don't know, that is absolutely their decision to take. Without a challenge even to that, perhaps these two writ petitions may not even be able to proceed further. All these aspects, but ultimately it has to be heard. So
And
either your lordship hears
the
it.
finding of the division bench.
Division bench, that is where there are several findings. We'll have to go deep into it.
The basic finding of the honorable division bench is like this. First of all, the requirement of collection of quantifiable data as had been provided. The honorable division bench has said that this aspect of the matter can be looked into by the DPC itself while considering promotion to the post, because DPC has got all the available materials before it, whether there is adequate representation of the community, whether the posts are available for on the reservation.
DPC or the appointing authority.
No, the honorable division bench has accepted a proposition that it will be considered by the DPC.
Now, that is another aspect. That's a completely new dimension that has been added. For the first time, it has been said that it will be the DPC who will collect the quantifiable.
But anyway, my lord, that is the judgment of the honorable division bench. And so far as the aspect of the efficiency aspect is concerned, as it was flowing from the Nagraj case and all, then the finding is that aspect of efficiency, going into an aspect of efficiency will be offending to the provisions of Article 14 and 15. But regardless of all these things, my lord, the position remains as on date. That's 2002 office memorandum which provided for consequential seniority and all, that still holds the field. And the kind of argument that, my lord, the respondent seeks to make in the case, that in the past there were promotions made and his position ought to have been corrected. Look, at any rate, my lord, those seniority were never challenged. And since in absence of these challenges, my lord, any challenges to the seniority position, my lord, now it cannot be contended that since something wrong was done in the past and their poetic justice has been met now, so the order is justified. That kind of a submission, my lord, will not hold good for this case. The reason being that, my lord, if your lordship will kindly see the here in the petition.
Mr. Chaudhary is appearing for both the respondents, 6 and 7.
No, only 6.
Only 6.
Is the same person who has been added as respondent number 5 in one case and respondent number 6 in the other case?
Well, respondent number 7 may not be very interested in the case, my lord, because in any case, my lord,
7 has perhaps already retired.
And because it will be a case
Very
of
well,
determination.
we'll then fix it for hearing.
Although the petitioner is retiring next month.
Even I am retiring. So your lordship will have it on a hearing day, my lord, either 7th or 14th.
subject to my learned friends available.
We'll have it on a hearing day for hearing
As your lordship.
as a regular matter, regular hearing matter.
No, that I'll leave it to your lord.
Your lordship can hear it on admission column itself.
Right, 21st September. The dates actually should be selected by the bar and been given to us so that we can pass an order.
7 and 14, my lord.
14th is all right with me.
No, no,
Subject to your
14th
lordship.
14th is not in,
7th maybe.
all right, 14th, all right.
14.
Subject to partner matters being available. Learned counsels, the bar submit that the matter needs to be heard extensively. And the judgment of the division bench rendered in a connected appeal, being writ appeal number so and so, along with other connected writ appeals has been rendered
It's not connected as such. On a similar issue, your lordship.
on a similar issue has been rendered by a division bench of this court by the judgment and order dated
It is 10/8/2020. 10/8.
10/8/2023. And that and the findings of the division bench may have some relevance in deciding the matter. Accordingly, matter be listed for hearing, admission hearing on 14th, 14 September.
Please, your lordship. This second application rejected by your lordship. Kildare was confirmed, my lord.
What is the first,
Rejection order is at page 31, my.
where is the FIR? FIR
FI is at page 14, my lord.
page
In my lord.
14.
14, 1/4. Where is not FI, my lord?
What is the stage of the investigation?
Lordship, it was last investigation date is lordship 10/4/2023, lordship.
Then what has happened after that?
Is up till there only, lordship.
Why?
Lordship, you have to inform lordship, earlier what have investigated, only one witness was investigated, lordship. While
No. You find out from the IO, what
Up
is
to
it
date.
done with the investigation?
lordship, up to date CD, lordship.
No, up to date CD is okay, but why the investigation has not progressed? Is it because the petitioner is also a policeman? He's a policeman.
Yes,
So policeman doesn't want to investigate other policemen.
he's a constable under 20th battalion.
Uh,
The government employee, my lord.
We'll direct the SP to reassign investigating officer if we don't get any progress.
Lordship, lordship. I will in the.
You obtain the
Up to date.
status,
Status.
let the learned APP obtain the status of the investigation carried on as it is submitted, that the last entry in the IO, in the CD is on
Lordship 10/4/2023,
10/4/2023.
lordship.
Stop. This being a second bail application filed by the petitioner. But there is no apprehension again.
But lordship, I have taken some of the ground, my lord.
No, is there an apprehension?
No, my lord.
They have not progressed.
But I am a government employee, my lord.
So you are not only government, you are a policeman.
Yes, my.
So there is no apprehension. They are not going to arrest you.
But my lord,
Get the up-to-date status by the next date fixed.
Return the CD.
CDB return for calling for up-to-date CD. List on 18th September,
Lordship,
15
can be
September,
a bit earlier, my lord.
15 September,
Oblige,
15 September. Mr. Debora appears for the petition.
oblige.
Yes,
But
order
right,
complied. Complied,
not compliant, Lord.
not complied.
Because if your lordship comes to page 37 of my additional affidavit.
No, first let us see the order,
Yes, sir.
page number.
Page 10. Page 10 of the
Yes, what is the direction?
operative portion, lordship, from paragraph in 7, lord. Or from 6, lordship. At page 11. However, in the impugned letter dated 02/01/2018, the respondent has taken another ground that the case of the petitioner could not be considered as he was already engaged in Singapore between 04/01/2008 and 04/01/2000. This is a new ground which has been taken by the respondent after the judicial pronouncement has been made in this by this court in WPC 3091/2016. This is not permissible. In view of the matter, the engagement of the petitioner at Singapore between 04/01/2008 and 04/01/2011 is inconsequential inasmuch as the application of the petitioner was made on 19/12/2011 and thereafter on 10/01/2012. It is to be noted that the petitioner at the time of making the application was not employed. In the view of the matter, this court is of the considered opinion that the impugned letter dated 02/01/2017 is vacated and the same is accordingly set aside and quashed. The respondent authorities are directed to consider the case of the petitioner for dependent employment, compassionate employment against the next immediate vacancy that arises in future.
Yes, then,
Now, lordship, if your lordship comes to the page 15 onward, page 15 onward,
15,
15.
yes.
These are the date of appointment of other persons. lordship.
No, you were pointing out to some additional.
Yes, lordship, this is very important. The additional affidavit filed by you. Now, if your lordship comes to page 37 of my additional affidavit. Lordship, go ahead. Para 2, lordship. Letter dated 15/5/2023. Para 2, lordship. It is apparent that before any decision could be taken from our end, you hurriedly filed a contempt petition against us for alleged violation of the Honorable Guwahati High Court. Or within 5 months after disposal of the writ petition on 19/2/2018. In the said contempt case, you have further alleged that in spite of there being vacancies, you were not appointed, whereas according to you, 3 other similarly placed persons were appointed on compassionate ground. It is necessary to point out that the said 3 persons, namely so and so and so and so and so, were appointed on compassionate ground as because all their applications and documents were in order and their appointments were against the deaths of their respective fathers, which is as per the provisions of the. As far as your case is concerned, without going into the merit of the case, we hereby inform you that by way of the order dated 19/2/2018 passed in WPC, we were directed to consider your case for dependent employment, compassionate employment against the next vacancy that may arise in future. Since 19/2/2018, no vacancy has arisen till date in the category of dependent employment, compassionate employment in our company. In such circumstances, we regret to inform you that your case for appointment cannot be considered as on date. Now, lordship, if I take your lordship to that page 35. This honorable court has directed on 3/5/2023 to take necessary steps for compliance. Now, page 35, lordship, if your lordship comes to the right hand side of the above top, the date of issuance of the appointment letter is 31/5/2023. This is also compassionate appointment law. Now they are saying that there was no post, and in 2023 also they are appointing. So there is a ego problem between of this.
Yes, why the not complied with?
Your lordship. The appointment is against the vacancies that occur on the death of the father or mother who was working. Here, these three names that have been given, they were appointed against the death of their parents, respectively. And it was done in accordance with law, all as per the scheme.
I will say make some more appointments so that notification is subsequently done. After the order of this honorable court.
922.
There is a share of ignorant violation.
Where is that impugned letter 2/1/2007? In the order, para 7, there is a reference to a letter 2/1/2007. Is it available here?
2/1/2007. Got it.
See, the direction of the court is to consider the case against next available vacancy.
Vacancy.
May I pass it over?
There is no vacancy as far as he is concerned.
Sorry?
Because this is not a general vacancy.
Ah.
It's not against the death of some other persons.
No. Para 12, sorry, para 7, page 12 of the learned single judge says, you are to consider the case of the petitioner.
Yes.
For dependent employment, employer, compassionate appointment against the next immediate vacancy that arises.
To the letter notice.
Next vacancy here does not imply or a general vacancy.
Sorry?
It does not imply a general vacancy. These
Then it is
appointments-
for you to get a clarification from the court.
This is an appointment solely on the basis of the National Coal Wage Agreement, the provisions therein.
No, the other persons that you're appointing,
Yeah.
you're appointing against what vacancies?
Against the death of their respective fathers.
So why are you not,
Yes, his case is over.
his
That's the
cases,
reason. He was rejected earlier.
that has been set aside?
So that is set aside, but he doesn't get restored to that position because of the fact that the vacancies have to be filled up within a year application. The purpose of appointment on the compassionate grounds, Your Lordship has seen is laid down in the Supreme Court. Only.
We are only an executing court. We are trying to find out why the directions of the court has not been implemented. Now, if you, according to you, this order requires to be clarified, then it is for you to go and file an application seeking further clarification. But an order cannot be interpreted. It has to be read for what it is.
No, that case, Your Lordship will have to see the clauses of the National Coal Wage Agreement.
We don't. We go by the order, we go by the directions contained in the order.
It does not mean any vacancy.
We don't know. The direction is very categorical.
Categorical next vacancy.
Next immediate vacancy.
Yes, but here, what is the vacancy under the Coal Wage Agreement?
So it is for you to get a clarification from the court that next immediate vacancy will not mean any vacancy. It has to be a vacancy relatable to the to a death or something like that.
As defined in clause 9.3 of the.
But these are not
agreement.
mentioned in the order.
The clauses of the agreement are already there, but even if Your Lordship.
Mr. Ahmed, you are a very seasoned and senior counsel. This is an order of the court.
That is.
You have to satisfy why this order is not complied with. The directions in para 7 are very, very categorical.
I understand.
If
that.
according to you, it cannot be implemented, then you have a remedy in law, which you have not taken recourse to.
Your Lordship, in that case, I will take time to file an application.
We are not giving you legal advice, but
No, no,
if this is the direction, then you can't say that
to an extent, your Lordship is right, but
if I'm right, then you're in contempt.
no, that's the reason I was trying to point out to the clauses of the.
You think over it and whatever, because this order is categorical. It says you appoint him. Consider his case. You consider the case,
Consider the case.
and if you think that because of this reason, that reason, it cannot be done, it's a different issue. But you have to consider him against next immediate vacancy available in future. Now, whether that
Exactly.
vacancy is a vacancy arising out of
A
death
general,
of
general
death
vacancy
or
or
regular vacancy is not given in here.
it's not.
It is not for you to interpret that, no, with this vacancy must mean only this
No,
vacancy.
that order is also vague, right, your Lordship. In that case, I may be given time to take a clarification.
Okay, in the past order, Lordship, in WBC 3091/2016, the order was passed on 01/08/2016.
Let us take up the matter after a week or 10 days so that they come back with their views, because
Okay, but the orders are categorical, Lordship, and direction has been made, Lordship. But despite that, they have been appointing others, Lordship, on compensation ground. In 2018.
we can give you time to reflect on this order and act. We can't give you time to file an appeal.
That is my right, your Lordship, I can, if I have.
No, you can, but you have not done so, but we can't give you further time for that. We can give you time for compliance of this order.
But there is no vacancy as far as petition is concerned.
That you'll have to satisfy by saying that there is the immediate vacancies are not available.
Not available. We stated that, we informed you,
Where is that letter?
the last letter.
31
In our
2023, they were appointed.
Who does it?
37 page, 37 Lordship. That order letter dated 15/5.
Page 38.
Definitely ego problem, Lordship, because of ego problem, because I have approached this honorable court, therefore, Lordship, they are not appointing.
We have nothing against any particular employee.
This is the reason. Because
All right, we will take it up after 1 week. You
paragraph 2 is
reflect
crystal
on
clear,
the issue.
If your Lordship makes it 2 weeks, because next week I won't be here.
To 1 week, 1 week. You
2 weeks, your Lordship, next week I won't be here at all.
sorry?
I won't be here in Guwahati next week. So can it be second week of September?
11th. Let it be on 11th, as prayed for by Mr. MZ Ahmed, learned senior counsel, appearing for the respondents to complete his instructions in respect of the directions passed by this court by order dated so-and-so, passed in WPC so-and-so. Mr. Dhor appears for the petitioner, who submits that the order, in spite of order or the directions of the passed by this court, has not been complied with till date. Matter will be listed again on 11th.
Lordship may observe one thing, that they have appointed on 23,
No,
one of
is there on record?
on 31/5/2023.
It's not necessary to record it. We'll record it in the order that we pass.
Right.
You can take back a copy of the petition,
Sure.
list on 11th.
Much obliged.
Applied.
So I am appearing for the respondent number 4. And affidavit is temporary, I think, so need 10 days time for filing the affidavit.
They've given you 2 weeks. Then 3 weeks earlier,
Within 10 days, we will file a petition.
You pay cost.
That's a very, within 10 days, we will file a.
NS N Bora Learned Standing Council, Social Welfare, PNRD.
90 days.
PNRD submits if further time be granted to enable her to file the affidavit on behalf of whom?
Take one service. Respondent number 4.
Respondent number 4. Prayer allowed list after 2 weeks. Mr. A. They appears for the petitioner who does not object to the prayer made. List accordingly.
If the order passed in the requisition is available at page 10 of 40% F 10 as a 10A. lot.
Service report is awaited
Yeah,
on
yes,
respondent 1.
It is listed for the first time after notice of motion or release. Office note docket,
Yes, service report is awaited.
yes, Lord.
Await service report on respondent number 1. List after 2 weeks.
In restore respondent to late, basically late RTS.
Huh?
In restore respondent 2.
You want to take fresh steps?
Yes, Lord.
Learned Council is permitted to take fresh steps on the correct address on both the respondents. Matter be listed after 4 weeks. Yes,
May please, your Lordship.
complied.
Lordship, in this matter, they had gone for a review of the earlier order, Lordship.
Who?
Lordship,
Department?
Petitioner, Lordship.
Petitioner. Then what has happened?
Lordship, that has not been brought on record, Lordship, review order, Lordship. One thing, Lordship. Secondly, Lordship, all the officers, those who were there, Lordship, they have been shifted to other departments. And some
Maybe,
retired,
maybe.
Lordship, that remains, Lordship, but they need to implement with the
Not
new
necessarily
order.
their
Lordship,
call. It
review
is
order.
their call. It is
Lordship.
their call to
Lordship,
impede or
I
not
am
to
just pointing
impede.
it out, Lordship.
Yes, it is their call.
My clients are not in office, Lordship.
My lord,
No, your clients, were they not in office at the time when the order
Lordship,
was?
they were there.
Then,
That doesn't go, Lordship. It will follow them.
yes, what do you submit?
my lord, I will bring this, my lord, the order that has been reviewed,
It has been reviewed.
my lord. My lord, only the distinction is, my lord, in the review, it has been modified that the petitioner has been, my lord, initially promoted. Thereafter, my lord, without serving any notice, my lord, that the petitioner has been, my lord, subsequently demoted. The honorable court has, my lord, we have proposed before the honorable court, my lord, has set aside the impugned order, my lord, by which we have been demoted.
Yes.
My lord, there is no any specification that, my lord, after.
Then what happened in the review?
My lord, review, my lord, it has been very specified by this honorable court that the onset the impugned order has been set aside. My lord, meaning thereby that we may be allowed to remain in the post to the post to which we have been promoted, my lord. That only, my lord.
Now you are in which post?
My lord, in presently, my lord, I am in grade 4 post, but I have been promoted to grade 3 post, my lord.
Where you had been removed.
I have been removed.
Now, my
So
lord,
according to the review order, you are now required to be in grade 3 post.
my lord, my lord.
Lordship, in the meantime, Lordship, he has also retired from service, Lordship. And Lordship, another thing,
Maybe
Lordship, after there were a lot of orders, Lordship, similar matters were there, Lordship. DPC was held, Lordship, and it was seen that, Lordship, his position was far below many other person to be promoted from grade 4 to grade 5.
My
So,
lord.
although he was in the list, something around 653, Lordship, only 9 were selected, Lordship.
My lord, that is, my lord, earlier situation. My lord, similarly, situated all the candidates, my lord, the number of repetition has been, my lord, filed, challenging this, my lord, impugned order of where, my lord, by which, my lord, we have been demoted. My lord, subsequently, that, my lord, on the basis of the repetitions, the similarly situated, the number of candidates has been, my lord, promoted to the grade 3 post, my lord. Lordship, kindly give me 1 week time. I will bring in record.
Mr.
all
B.K.
the-
Das, Learned Counsel for the petitioner submits that the order dated 30/05/2019, 3005, passed in 8/1/2017, has not been complied with, and therefore the contempt petition has been filed. Stop. However, a review has also been preferred whereby the order has been further clarified. Mr. Das craves leave of the court to produce a copy of the review order before the court by the next date fixed. Mr. M. Bhagavati appears for respondents 1 to 3,
All the response.
all the respondents, who submits that in the meantime, the respondents have them, they are superannuated,
Transfer lordship, superannuated lordship,
respondents,
lordship, all of them.
as well as the petitioner. So, be that as it may, matter be listed after 2 weeks, enabling the counsel for the petitioner to place the copy of the order passed in review by this court.
Much of it.
The contempt case, my lord, already at stage 8, my lord. Stage 8. Annexure 1.
Whether the notices have been served,
Annexure to only that writ petition notice was served. But today they told me that notice was not served. I don't know. My senior is out of state.
you take steps.
Okay, my lord.
Learned counsel for the petitioner is permitted to take fresh steps on the respondent within 1 week from today. Fresh steps by registered AD. Learned counsel for the petitioner is permitted to take fresh steps by registered AD within 1 week from today.
Lordship, I want to submit one thing for the benefit of him, Lordship. The incumbent is, Lordship, he's already transferred, Lordship, in 2020 itself, Lordship, the contempt, Lordship. So perhaps he has to impute the new incumbent in this case, Lord.
That is his call.
Lordship, Lord. I have also.
You don't have to convey this through us. You can convey it to him directly. Why do you have to take it through the court? Steps be taken within 1 week from today. Matter be listed after 2 or 3 weeks.
Obliged.
May it please your lordship. This petition has been declared before this honorable court in the year 2012, your lordship. Praying for the promotion of the petitioner to E1 grade with prospective effect as per that at the time of prevailing policies, your lordship, under the Corporation of Hindustan Paper Corporation Limited at Nagaon paper mill, lordship. And also
That has been wound up.
lordship,
Company.
Mill has been closed, but the corporate office, at my information goes, corporate office and 2 mills has still been running under the Hindustan Paper Corporation Limited. Corporate office, which has been in Delhi, still been running.
Running because it is under I think it is these steps are being taken to compulsorily wind up the corporation in terms of the directions of the NCLT. Then
So your lordship, since the petitioner has been referred to another court in 2012. And
no, what prayers do you want now?
my prayers is limited prayers. He has to promote it in E1 grade, your lordship, executive grade 1, as your lordship similarly situated person, as the one may I draw back your lordship to the
So today you have only claims, monetary claims.
no
Then
regarding the E1 promotion to the E1 grade, your lordship. Even
when the corporation is not there, the offices are not there, the mills are not there. For what purpose will the promotion be effected?
so your lordship,
Then
if this honorable court considered my prayer of the petitioner goes to the repetition, if the court has find that yes, natural justice body has been violated, he ought to have been promoted. On that
Mr.
ground,
Counsel,
My prayer is that since the corporate office, this company today, as on today, is still in existence. So my prayer is also is in exist here. So at that time, I also have been promoted to E1. Those
Who will decide on this promotion? For what purpose? Who will decide? What is the status of the winding up process?
the that thing has to be not been on knowledge or
We close this writ petition with your liberty to go and approach the corporate office.
may take a time to a time may be granted to me to the instruction to my client also regarding the entire factual of the matter, legal practice. On next day, I will put on record if the petitioners has intention to close this matter and withdraw this petition, your lordship, then if the relief is not been survived,
List on 8th. We'll give you time delay.
lordship,
Matter be listed again on 8th, enabling Mr.
H. Burwal.
Borua, H. Borua to obtain instructions as in terms of the in order to complete his instructions as to whether the writ petition ought to be pursued any further or not.
Lordship.
Matter be listed again on 8th.
Lordship.
None appears for the respondent. Yes.
May I please? Our instruction was memo was listed. Yesterday night, learned senior counsel Mr. Kawala informed my senior he has difficulty to take up to in this case today because there is performing in his house.
Who has informed?
ONGC advocate Mr. Kawala.
It is for him to submit. Why are you taking the submission away from his
Nothing
mouth?
is stating. Lord.
No, he is
no,
not stating, he wants to argue.
Making submission, that's why. Lord.
My lord, petitioner have filed the amended writ petition, my lord.
Ah.
In that case, my lord, we will be filing the affidavit in opposition.
Again,
Yes,
what
because
is
there
the
is some
matter?
amendment in the
What
petition.
is the matter about? What is the issue about?
My lord, the matter is regarding the appointment.
Why are
of
you
the
worried about the
post-
senior counsel from the other side? You argue your case.
Lordship, because of their information, we are not fully prepared. Lordship. That's why I am applying your lordship.
want to fight one. Amendment.
And regarding selection appointment, in spite of being my position above the private respondent, I have been deprived of a technical reason because of stating that PRC not submitted residential status.
It is not related that he was for fight. This application rejected because the listener's certificate is not been clear. Yes, he has not been clear. Instead of it is clear, he submitted verification report. Not clear. That is why you are rejected.
Learned counsel appearing for Mr. Singh appearing for ONGC.
My lord,
Submits that
respondent number 325.
respondents 3 to 5 submits that affidavit in opposition is required to be filed in response to the amended writ petition filed by the petitioner. Mr. J. Ahmed for respondent number 10 makes a similar prayer. Anyone else? Mr. H. K. Sharma appears for respondent number 7. MS so-and-so appears for respondent number 1. CGC. ESN. Mr. Day appears for respondent number 8. Then please tell me your name. AP Datta appears for respondent number 11. All the counsels for the respondents submit that opposition is affidavit in opposition is necessary in view of the amended writ petition 5. Therefore, they pray for some time. Mr. F.U. Borbuya, learned counsel for the petitioner, does not object to the prayers made. Accordingly, let the matter be listed after 4 weeks, enabling the
Mm.
learned councils to file, exchange the pleadings.
If I am paying for prior to that, 2 weeks, because already that issue earlier it was set aside. Subsequently, review petition filed to respond.
You don't want to do it today, you do want to do it after
They
2
also
weeks.
requested us to do all my friends also.
That's all right. What is there to request you? Why will they request you? They're appearing here.
Since they are colleagues.
They must have asked you for your consent,
Consent, yes, Lordship.
not a request. They're appearing, they will make a request themselves.
After 2 weeks, Lordship.
After, because they are filing amended, they're filing an affidavit, you may like to file a rejoinder, so this will take some time.
Date, I'm paying for.
3 weeks, list after 3 weeks.
So